All right, Lieutenant Dooley, good morning. Is there a particular way you wanted us to, excuse me, work through the calendar?
Good morning. It looks like we have everybody on except the person in 3 South. So the order is at your pleasure, sir.
Great. Okay, we'll just go in the order the calendar was published. So position 1 is George Bass.
Good morning, Judge. Jackie Pastor, Mr. Bass, how you doing?
I'm well, sir. Yourself?
Just fine. We anticipate a potential resolution today. The DA just needs some time to call the witness.
Fantastic. Let me see if that would be 2 South. Let's get Mr. Bass on the screen real briefly. Mr. Bass, can you hear me? Let's see, where's 2 South? That's empty. So Lieutenant Dooley, I got position 1, Mr. Bass, as being in 2 South. Has he relocated?
Yes, sir. Mr. Bass is on 1 North.
Okay.
When you guys look up the calendar, is probably days in advance and anything could happen. So staff looks it up the day before.
Got it. Okay, well, let me make 2 South go away and we'll go to 1 North.
That's him in 1 and 1 away.
Yeah. We'll get him. Hey, Mr. Bass, how you doing today?
I'm doing good, sir. Good morning to you.
Good morning to you. I'm Judge McBurney. Your lawyer, Mr. Patterson, is here in court. He has been talking with the prosecutor, and the prosecutor, needs a little more time, but just this morning, to do a little work on the case. So we're going to circle back with you. I'd ask you to stay in or near this booth, because once Mr. Patterson has heard back from the prosecutor, I think we're going to try to take care of your case, okay?
Yes, sir.
All right, thanks. So don't panic. I'm going to mute you again, but I promise we'll circle back one way or the other. All right?
Yes, sir. Thank you.
Thanks. All right. Position 2 is Octavius McGee, and he was in U.S. Marshal.
That's my case, Judge. Good morning.
Good morning. Is Mr. McGee still in federal custody, or is he back?
Yeah, he's been federal custody. He's in federal custody in Miami. He's set to go to trial there on 1/31/2020.
This is the one where your colleague sent something to Ms. Nelson. And I think his trial got reset because we were going to get him, and then they said, no, we're holding on to him because they still need to try. They're going to try to try him in federal court.
That's correct.
Okay. So, Ms. Bernard, we're just trying to move Mr. McGee's case.
Judge, I think the state has an announcement.
Oh,
Yes,
okay.
sir. So on reviewing of the case and looking at the posture of the evidence in the case,
Can you unmute your microphone so others can? There we go.
after reviewing the evidence in the case and looking at what Mr. McGee is facing in Miami, and the state's concern that we will move to non-cross formal charges.
What is Mr. McGee looking at in Miami?
Trafficking charges, Your Honor. So what the email like I didn't tell me 2 years, but
Federal trafficking will definitely be 800. I mean, they'll do it in months because that's how they do it federally, but it will be lots of 12s of months. So, okay.
One of the issues with Your Honor is the address our case for minute to sit. The amount in question is on the amount that GBI will ever test.
Okay. Makes sense. So you will get a proposed order to Ms. Nelson next few days.
Yes, sir.
That'll take care of it. Ms. Bernard, I'll sign that null process, and that ought to take care of things for Mr. McGee.
Okay, thank you, Judge. May I be excused?
If that's your only case,
I believe it is. If
Great.
it's not, you'll know how to reach me.
we do. All right. Thank you.
Thank you. Bye-bye.
Position 3 is State versus Daja James.
Here at the South Annex, Your Honor.
There, all right, are you Miss James?
Yes, Your Honor.
All right, well, good morning. Let me give you big on the screen there.
Good morning to you too.
There we go. Okay, let me get the James Lawrence. All right, and who's representing Ms. James? I have a Shannon Render listed on the calendar.
He was my lawyer for my last case. I'm being represented by Scott this time. I'm not sure if he's on or not.
Can you say the name of your lawyer again, please?
His name is Scott. I don't even have his last name.
Okay. All right. And you know Scott's representing you on this case, or is Scott representing you we had something in Oklahoma, it looks like.
Yes, sir. He's representing me in this case.
Okay. Well, let me just look that up so we're all saying.
We thought that my court was at 10 o'clock this morning, so that may be why he's not
All
on
right,
it.
we may circle back. I'm just trying to see if you filed something in your case that would let me know who the Scott is. Okay. Okay, so we'll wait and see if Scott's his first name.
Yes, sir.
Okay, Attorney X joins us at 10. Just so you know, Ms. James, what's going on. I signed a warrant for you back in August of last year that alleges that while you were on probation for this Georgia case, this 18 SC case where you were charged with robbery and battery, you and two other people. While you were on probation for that, you got in trouble, what was a while ago, it would have been in January of 2019, so 3 years ago, for something about credit cards in Oklahoma. That's what got you stuck here, and we'll need your lawyer to talk you and me through your perspective on it. And then I think he will want to talk with the prosecutor as well. Ms. Charles, who's sitting in court here, may have some thoughts about ways to resolve all this, but we need to get your lawyer in the mix. So if you don't mind sitting tight, we'll see if around 10 o'clock Scott joins us, okay?
Okay, thank you.
Sure. All right, position 4 is Santana Phillips.
Yes, sir.
You're Ms. Phillips?
Yes, sir.
Great, good to see you. Is Ms. Patel on? She is on. Hello, Ms. Patel.
Good morning, Your Honor.
How are you doing?
I'm good. How are you?
All right. So we were together, I don't know if Ms. Phillips joined us or if it was just the lawyers and myself talking, but about a month ago in December, and it sounds like, Ms. Patel, you were looking for a program for Ms. Phillips.
Your Honor, Ms. Phillips was just waiting on housing for BHTC. It was a track 1 referral. I spoke with Mr. Abrams and he said that they've located housing and she is expected to be released to them January 26th. I'm not sure if he sent the orders to Ms. Nelson yet, but the only thing outstanding for Ms. Phillips that I was trying to work on is that she has a CP case that Ms. Charles and I were trying to divert into BHTC. I've reached out to 2 deputies at the DA's office, and I'm hoping to hear back next week on that. But the CP case, she has a unsecured judicial release, so that should not prevent her from going into BHTC.
Okay, so at a minimum, when the housing is available, and it sounds like that's going to be early next week, I can sign the paperwork for Mr. Abrams that will get Ms. Phillips released on the 18 SC case. The CP will not hold her because she's got the UJR, but ideally we'll get that folded in. It's also a track 1, I think we call it diversion now, but, and this I guess would be pre-indictment diversion, but get that CP case into the HTC as well.
Correct.
Okay. All right, Ms. Charles, anything you want to add on Ms. Phillips' situation? Let me look. Ms. Phillips, did you follow all that? Do you have any questions about what we just talked about?
Yes, so you say I would be released to the program on the 26th?
So that is what Ms. Patel thinks will happen. She doesn't run the program, but she has certainly been in touch with the people who run it. And the 26th makes sense. That's a Wednesday, and that's when they do orientation at accountability court at Hope Hall. And so what they typically do if they've lined up housing is make that housing available for Wednesday evening. They'll come get you Wednesday day. You'll have some orientation at Hope Hall, and then you'll get to the housing, and then you'll be in the program and start participating. Does that make sense?
Yes, sir.
Okay, now that's the plan, and hopefully the housing comes through. Mr. Abrams has been working hard on that. This gentleman with accountability courts, Ms. Patel has been bugging him regularly, as she should, to make sure he's following up on it. So hopefully that's what happens on Wednesday, and I'll be looking for the paperwork to sign that would get you out. The important thing you need to do is stay in that housing they get you and show up when they need you to show up for accountability court, okay?
Yes, sir.
All right. Ms. Patel, thank you for that update. Do we need to talk about anything else with Ms. Phillips?
No, Your Honor.
All right, thank you.
Thank you.
All right, next is position 5, State versus Arnold. I've got him on the calendar in 4 North, but I bet that's not where he is.
Your Honor, this is
Yeah.
Sergeant. He's in call. I have him on now. He's here now.
All right, I think we just got him on the screen. Great. Good morning, Mr. Arnold.
Morning, Judge.
Let me get your warrant up. Okay. Ms. Patel, are you handling this for Mr. Arnold?
Judge, he's mine. Good morning.
Good morning. How are you?
I'm good. How are you?
Okay. And Ms. Wood is handling things for Mr. Arnold. And the petition or warrant that I signed a while ago, June of 2020, alleges that in May of 2020, Mr. Arnold, I don't know if he was arrested or convicted, but something in Fulton County about drugs and maybe a gun. Ms. Wood, why don't you tell me where the defense is, then I'll hear from Ms. Charles.
Judge, Your Honor also recently signed an additional petition from Probation Officer Dixon, I believe. It's for a Wilcox County arrest.
Oh, yeah, I've got it right here. Ms. Nelson got both of them for me. Got it. And that's much more recent. So in the end of June of last year, it is alleged that Mr. Arnold had stuff on him that he shouldn't, I guess, when he was taken into custody in Wilcox.
Correct, Judge. So I've spoken, Mr. Arnold and I had a lengthy visit yesterday, and then Ms. Charles and I have also been speaking on this case. If I could have a brief breakout session with Mr. Arnold, I know it's down for an actual hearing. We might be able to work something out if I could have a breakout session at the end of the call.
Okay, let me check one thing before we do that. I'm fine with that. So there's also a CP case out there that doesn't need to get in anyone's way if it's not getting in anyone's way, for possession of cocaine with intent to distribute and MDMA and marijuana and another gun. Is that what is the basis of the first warrant I was talking about?
Yes, Judge.
Okay, that's that one. So the older warrant is this CP case for which Mr. Arnold has a bond. Is that a bond? I guess then it's a bond he made because that was in May of 2020, and in June of 2021, he managed to be in Wilcox.
Correct.
Okay. So Mr. Arnold, I'm gonna move you in a minute into a breakout room. In that breakout room, your conversation is private. I mean, anyone who's with you can hear you, but I can't, the prosecutor cannot hear you. You and Ms. Wood will be able to speak freely about whatever your situation is, okay? Let's see if I can make this work. And Ms. Wood. All right, when you guys are done, just pop back into the main room and Ms. Wood, let me know that you're back and we can figure out what, if anything, we're gonna do with Mr. Arnold's situation, okay?
Thank you, Judge.
All right, something should pop up on your screen that says, click here. All right, it worked. Great. Position 6 is Wallace Myron. Oh, all right, we'll come back to that. Position 7, Reginald Arnold.
Good morning, Judge. My name is Kat Lake. I'm a public defender, and I'm here for Mr. Arnold. I believe he is in 3 South, and I believe the deputy told us that everyone was here except for 3 South. Am I right? Anyway, we are ready for that bond hearing, Judge.
Okay, Lieutenant Dooley, should we come back to get Reginald Arnold, or is that someone your team is able to get for us?
I've called the floor a couple of times. I'll call them again. I don't know what's going on, but give me a few minutes. I'll verify.
Okay.
Thank you, Lieutenant.
Thank you.
Yeah, just barge in when you find him. Send something in the chat or just interrupt. But we'll move to the next case. See what we can do.
Receive. Thank you.
All right. Position 8, Tiffany Singer. Any chance Miss Singer showed up? Miss Singer was, who's handling? Is that also Ms. Wood?
No,
Ms. Patel. Ms. Patel?
Yes, Your Honor.
Ms. Singer was released from Haralson County 2 days ago. So she had no notice to be here. We did again an order of production, and the goal was to get her here, and unfortunately signals crossed. So I think what we need to do, she's got a big old bond, and we're about to start bond forfeiture calendars again in Fulton County. So 24/7 one-call bonding company will want to bind Ms. Singer with that $100,000 bond. But we will do a notice calendar, getting notice sent to the Singer's address of record, and we'll try again with plea and arraignment in this case. I think that's the best we can do. Ms. Charles, anything else you want to add in Ms. Singer's case? All right. Ms. Patel, does that make sense?
Yes, Your Honor.
All right. We set for notice. Now we get to State versus Gaines, Simone Monet Gaines. That's Ms. Wood, but how about is Ms. Gaines here? She's on bond, so she needs to be on the call or in the courtroom. Okay, we'll call that again. And it's, I think Serge Jerome is not doing cases right now. Right, I'm thinking of the right guy. So he would not be handling this case, but we need Ms. Gaines to show up. Figure that out. The only other case I've got is Christopher Coleman. Oh, we're taking a plea also. That's not on this calendar. I forgot.
Yeah, my client said he was on his way up 5 minutes ago, so we should be here momentarily. And the reason I was over here is I was looking for the plea form to go over with.
Yeah, I'll print one out. It's not on.
I didn't see one over there.
Yeah, we were out last time and I thought, well, my staff's not coming in, so my thought that Ms. Nelson would put more out there. It's a silly thought because she's not here. But I'll print one out. I'll print two out.
Judge McBurney,
Yes, ma'am.
Arnold is ready in 3 South.
Great. We will do that in just a second. Let me print this out for Mr. Mellon. That'd be great if you guys are working through that while we're handling this bond here. Hey, Mr. Arnold, we're going to get started in just a minute, okay?
Yes, sir.
Here's one. This will be all you need. Thanks. Right there. Yeah, great. All right. Ms. Rivers, good morning. Are you able to hear us?
Good morning. Yes, I am, Judge. I'm ready.
Great. Then let's get on the record in position 7. It's 21 CP 202539, State versus Reginald Arnold. Mr. Arnold is appearing from the 3 South Booth 1 at the county jail. His attorney is appearing with Lake remotely as well. Mr. Abate is here in court. I met Mr. Arnold a while ago. I'm sure Ms. Lake will give me the timeline, but I inherited his unindicted case because I was the presiding judge the week his bond hearing was argued. It was argued by a colleague of Ms. Lake's. At the time, I deferred ruling. I heard a fair amount about the situation. The allegations are, of course, that Mr. Arnold killed someone, charged with murder, but that maybe it was self-defense. Mr. Arnold was injured in the situation, as evidenced by his appearance now. It was represented to me by Mr. Arnold's attorney at the time that he was fairly seriously disabled and wouldn't be a threat if he were released on bond. Mr. Abate shared some information at the bond hearing that was supported by some documentation from the sheriff's office that Mr. Arnold had in fact gotten in fights, or at least a fight in jail, where he was in a position to attack someone or at least strike someone, which was very inconsistent with the way in which Mr. Arnold's attorney had described how Mr. Arnold was and the lack of risk that he would pose to harm others should he be given a bond. And that's sort of how I left it. But Ms. Lake very appropriately flagged this as it's been more than 90 days, and Mr. Arnold is entitled to a bond. And so we need to work through that discussion today. Ms. Lake, I'm going to start with you. You can share with me anything you want about Mr. Arnold's situation and correct anything I'm misremembering from what we worked through before. I know you weren't there, but you may well have spoken to your colleague.
Thank you, Judge. So, Your Honor, you got everything right, with the sole exception that Mr. Arnold was not injured during this incident. In fact, I believe the only evidence that the state has that Mr. Arnold committed the crime that he's alleged to have committed is that he was at the apartment complex at the time that this incident occurred. I have seen nothing further from the state in the way of evidence that Mr. Arnold actually did this. Mr. Arnold is not a flight risk because this occurred in April. He didn't even know that a warrant had been taken out for his arrest. He didn't know he was in trouble, and he didn't run. He is born and raised here in Clayton County. He went to high school in Clayton County. His mother, his grandmother, and his 7 siblings all live here in Clayton. But Judge, in August of 2021, he was injured in a separate incident. He was shot, and a bullet fragment was lodged near his spine in his shoulder. And Judge, that's why he's in the physical state that he is now. He does need medical treatment that he's not getting at the jail. He needs physical therapy so that he can work on regaining mobility in his left arm and his left leg. And if physical therapy doesn't work, he'll need additional surgical intervention. And Judge, his doctors are afraid that as he remains in jail, not getting the help he needs, that the bullet fragments could become dislodged and cause a stroke. So it's very important to us, Judge, that he's able to get the medical treatment that he needs. Your Honor is correct. He has been in custody now since the expiration of the emergency order, since the tolling of the 90 days. He's been in 114 days since that expiration on September the 29th, 2021. Your Honor heard bond that the day before that, so September the 28th, 2021. And I read through the transcript. I understood Your Honor's concerns to be twofold. First of all, the incident at the jail that you mentioned. And Judge, I have gotten the incident reports from that incident, and a bunch of sheriff's deputies reported about that incident. Most of them don't even mention Mr. Arnold's involvement. Most of them say that there was a fight that broke out between 2 other inmates, one of whom was in a pod with Mr. Arnold, another inmate actually ran into that pod unauthorized. He's not even supposed to be in there, and started beating up the person in Mr. Arnold's pod. Mr. Arnold's involvement is mentioned only in that he tried to defend the guy in his pod by hitting the other guy who had run in without authorization. So Judge, I believe that incident, as described in the multiple sheriff's deputies' reports, kind of belies the state's representation back in September that he was an aggressor. He certainly was not. Judge, I believe your other concern was a failure to appear in Judge Barwick's courtroom, which is why I'm here. Not the only reason I'm here, one of the reasons I'm here. Judge, that has been set aside. I was able to show the ADA in Judge Barwick's courtroom that Mr. Arnold was in custody at the time that the bench warrant was issued. And that bench warrant was set aside by consent. Your Honor, you've heard all this, but I've already touched on Mr. Arnold's ties. He would live with his long-term partner, Katira Bussey, in Rex, Georgia. He's been at that address now, I believe, for 2.5 years. He's been with Miss Bussey for 4. He takes care of her daughter, Kiki. Judge, before he was shot and before he was unable to continue working, he worked for the Clorox factory. He is not a risk of intimidating witnesses. He does not know the witnesses. And Judge, in his physical state, he is not able to intimidate or to harm anybody. He's not a flight risk. He can't even get up to the attorney booth so that we can have a hearing with him. He's not going anywhere. If there's anything else that I haven't touched on that Your Honor would like to hear about, I'm certainly happy to address it. And the final thing I'll say, Judge, is that, half a year later, I don't have any evidence from the state that Mr. Arnold murdered anybody, except that that he was in the apartment complex, that he had visited the woman in her apartment whose boyfriend was subsequently shot and killed, and that the boyfriend came over while he and his friend Chelsea were visiting the apartment. That the boyfriend and the friend that he was visiting got into a heated argument, and that Mr. Allen, the decedent, left, and that Mr. Arnold called Mr. Allen to say, "Hey, come on back, man. Like, you can't kick in the door to this apartment and leave your girlfriend and her children in this apartment where they can't lock themselves in at night. You got to come back and fix this." And then he left. So he didn't know anything about this incident, Judge. And I spoke with the friend of his who drove him to the apartment to visit with Courtney. Her name is Chelsea. I believe the state has spoken with her as well. And she confirmed, yeah, we drove over there. We visited with Courtney and Mr. Allen. And then, Courtney and Richard Allen got into a fight. So we left. Judge, I don't believe that the state has any evidence to support the allegation that Mr. Arnold is the one who shot. Nobody saw him with a gun. Nobody says that he was found with a gun and the shell casing or the bullet found in Mr. Allen's body matched the gun that he was found with. Nobody says they saw him shoot. Nobody says they saw him running away. Judge, he's entitled to a bond. If he is entitled to a bond, which he is, he's entitled to a bond that he can make, because we know that an unreasonably high bond is essentially no bond. Given that he's going to face medical expenses, Your Honor, I would ask for no more than a $10,000 bond.
All right, couple questions.
Sure.
Questions. Tell me about the case in Judge Barwick where there was a failure to appear. This is an open felony case?
Yes, Your Honor, it is a burglary from 2015, and the failure to appear occurred in 2016. Mr. Arnold was in custody at the time, and it escapes me where, but I can find that information out for Your Honor if you like.
No. I mean, you convinced Judge Barwick and that's sufficient, but we've got then a gentleman for whom you're seeking bond on murder charges, who's got an open, active, unresolved burglary case in another courtroom.
Yes.
Does he have any other open cases? Is he on bond for anything else?
So, Judge, I believe that the court heard about a 2020 misdemeanor in Clayton County. I do believe that that's still open.
Okay, I was thinking felonies, but okay, good to know. So there's the old burglary, now 7 years old. There's a more recent misdemeanor from Clayton. Those are the only two cases for which you believe Mr. Arnold is on bond that we want to layer another bond on top of.
Yes, Your Honor.
Okay. Is it your understanding, and you may be speculating, and that's okay, just tell me I'm speculating. Is there any connection between Mr. Allen being shot and killed, Mr. Allison being shot and killed, and then Mr. Arnold getting shot a few months later? Or Mr. Arnold just happens to be connected to shootings in 2021, and one of which he got shot?
Yes, Your Honor. So there is no connection. I am any connection. It would have been 4 months later. So this is April of 2021. Mr. Arnold was shot in August of 2021. I don't believe that he knows who shot him. And yes, it seems to me, a privileged white woman, like this is a really strange coincidence. And I'll just point out, Judge, that that shooting and incidents where people are shot are more common in communities of color and impoverished communities. I think it's less of a strange coincidence, perhaps, in Mr. Arnold's world than in ours.
Okay, thank you for that. Is Mr. Arnold able to wear an ankle monitor given his medical situation?
Yes, Your Honor. I would ask for the county to fund it if Your Honor is inclined to have him wear an ankle monitor. But he can wear an ankle monitor, and he can make sure that it's fully charged at all times.
If Mr. Arnold were to be living in Rex, Georgia, where would he be getting the necessary medical care that you described?
So, Judge, I know he's been receiving care at Grady. I believe he would continue going to Grady, and that Miss Bussey would help with the transportation. But I'm not sure about that. Mr. Arnold, am I mistaken?
You got it right.
I'm getting a thumbs up.
Yeah. Okay. All right. Those are helpful answers. I appreciate that. Mr. Abate, you've been sitting quietly waiting for your turn. What do you have to say in response to what you heard, or whatever you want to present?
Well, I'll start with, it is correct, we are past the 90 days based on the holding order.
Right, I'm sorry, I forgot all about that. That was my first question for you, and then cover what you want to cover.
Yes.
Based on your internal investigation, where is Mr. Arnold's case in the pipeline?
So from my understanding, speaking with the individuals who are handling the indictment intake, we are about 30 days out from indicting Mr. Arnold with charges pressing forward.
Mr. Abate, I can't hear you.
I'm sorry. I'm sorry, Ms. Rivers. We are about 30 days out from indicting Mr. Arnold on the charges in which he arrested, as well as a few additional charges through the investigation of the DA's office. In addition to the arguments.
I am so sorry to interrupt. Is there another microphone that?
Is he hard to hear?
I can't hear him.
Okay. Do you mind going to the podium? Yeah. Thanks. We're going to see your socks.
Thank you.
So I'll repeat, I apologize. Based on speaking with the case intake individuals who are handling the indictments in our DA's office, We're about 30 days out from indicting, presenting to the grand jury an indictment for Mr. Arnold on the charges in which he was arrested. As the court knows, there's a backlog of many cases, and this is one that is in the pipeline to be indicted, which is behind. Unfortunately, I would agree with Ms. Rabb based on the law. Mr. Arnold is entitled to a bond, but in the state's opinion, the bond is commensurate with the charges in which he was arrested. I won't belabor the facts, as Your Honor heard it in the last bond hearing, as well as with Ms. Rabb a few minutes ago. But he does, as Your Honor heard about last time, he had 3 FTAs. One was out of Fulton County, the Fulton County case, which we heard he was in custody at the time. But he also has 2 additional ones that were both in 2014 and 15 at DeKalb and Clayton County. I would bring to the court's attention. Currently has a Clayton County hold with no bond status.
In connection with the misdemeanor or something different?
I think it's something different. I'm not 100% positive. I'll hand it to the court. I can't see the warrant. I can see on the down screen there is a Clayton County hold. You go to the document tab, it's confirmation that there is a hold, but it doesn't say what exactly the hold is for. So it's very possible it could be a misdemeanor, or it could also be different. He was on probation in Clayton County for a burglary. Years 2016, so very well maybe that a violation for that. He also has 2 additional felony convictions, both out of Clayton County. One for theft by receiving and possession of a firearm, fairly traditional felony. And in 2016, we had an ID financial transaction card theft, also out of Clayton County, followed by burglary. I would submit to the court that there is a risk of intimidating witnesses, as Ms. Defense Counsel did say. Ms. Chelsea, who was an individual or witness that the defendant arrived to the home with, as well as the individual whose home they went to, Courtney. They both know him have known him for a number of years, and there were Ms. Courtney as well as another individual did ID him on the scene. Minutes before the shooting. The shooting occurred outside of the apartment, not inside the apartment, where the argument between the victim and Ms. Gordon had occurred. So Ms. Ratz is correct that they didn't see the shooting, but the vehicle in which the defendant arrived is seen minutes later leaving the apartment complex.
And that's what I remember from your presentation before, that at least at the time you were presenting, there was a before and an after, but the during you had no visibility into.
That's correct, Judge. And there are phone records that place him, at the scene before and right after the shooting, as well as he is the one who called the victim to return back to the apartment after the altercation occurred. In the state's opinion, based on the seriousness of the charges, a bond no less than $100,000 is appropriate based on the fact that he is charged with murder. He does have holds out of Clayton County. I think all of that would guarantee his appearance in court when his cases of that nature he would release that bond.
Thank you. Another judge taught me how to find holds, and I can see there is indeed a hold from Clayton County. 2020 CW 55, and it may go on beyond that. But that's something Mr. Arnold would need to work through if he were able to post the bond that he is going to get, because he is now statutorily entitled to one, unless I found he was such a flight risk that wasn't appropriate. I don't find that. But Ms. Lake can help Mr. Arnold work through whatever the Clayton situation is, or someone in Clayton can. That's where he goes next.
I'm so sorry, Judge. I'm having a really hard time understanding you and Mr. Abadi.
Okay. Well, the good news is we can hear you.
Okay.
Well, I'm required to set a bond, I think, at this point, given the time that has passed. I don't have in front of me, because the one thing I can't find in Odyssey is what the complaint looks like, meaning all the different counts, and that's not maybe a source of delay. I just can't break on the record the dollar amount out across the offenses, but I will let everyone know what the total dollar amount of the bond will be.
I forgot. Before you
Make sure you're talking to the microphone.
before you make that announcement, there are two family members from the victim's family who are present. We just wanted to address the board quickly. I understand that he is statutorily entitled to a bond, but they wanted to.
They're statutorily entitled to be heard. And I should have asked, I thought maybe we heard from them before, but every time we're talking about Mr. Allison, victim's case, his friends and family members have a right to be heard. Are they here or are they?
They are present.
Okay, great. Mr. Abate, if you just sort of negotiate who's who and have them come on up, that'd be great. Take the microphone just because of the difficulty we're having hearing folks, if that's okay.
Hey, Judge McBurney.
Yes, sir.
Hey, Scott Fortis here. How are you?
I'm well. How are you?
Good. I have Deja James on. It's a violation of probation.
Yes, you do.
I have another hearing going on. I was wondering if I could just go back and finish that and then come back to you.
That will work fine. What time do you think you'll be back, ballpark?
10:30 latest.
Okay, we'll be here.
Okay, great. Thank you, Judge. Sorry to interrupt.
No problem. Thanks.
All right. Thank you.
All right. Please tell me who you are. Okay, I'm gonna need you to speak up a little bit, if that's okay. Ms. Cloud, thank you for being here. How are you connected to Mr. Allison?
I'm sorry, I cannot hear her at all.
Okay, so if it's easier for you to sit, you could sit at one of the tables, but the court reporter needs to be able to hear you.
Okay.
All right, so lean on in. So you're Ms. Cloud, and you're telling me how you're connected to Mr. Allison.
My niece is his daughter.
Got it. Okay. And Ms. Cloud, I do want to hear from you. I just need to make sure you understand that because of the law, I have to set a bond for Mr. Arnold because he's been in jail, not having been indicted for more than 90 days. Knowing that, I still want to hear what you have to say because you may have thoughts about what the conditions of bond should be, or just how things have affected your niece, you, anyone else.
It's been about 270 days since we lost Walker. Every day I hear my name saying,
Judge, I'm so sorry to interrupt, but I am going to object and ask that any impact statement be limited to Ayala factors.
Okay, overruled. Keep going.
I hear my niece every day. She asks me what happened to her dad. She's been having difficulty since it happened, not just one child, but all of them. Mr. Allison, he takes care of 7 kids. 3 are biological years, the rest of them are still his kids. We're sitting here planning on that term release tomorrow for his birthday. We're sitting here in court today for a month. Yes, I understand he needs someone, but I feel like that, or we feel like that it should be the next. Because we don't get our dad. We don't get to hold him. We don't get to go to his shows. We don't get to be able to talk to him. His kids can't see him anymore. We just want justice for him.
Thank you, Ms. Cloud. I know it must be difficult as you approach certain anniversaries. It sounds like Mr. Allison's birthday is tomorrow. And based on the numbers you gave me, soon will be the anniversary of his death. And those will be difficult days for you, those many children for which you care and was responsible. And there aren't easy answers here. I very much appreciate you being here to represent the perspective of the family. I also hear you loud and clear that you think the bond should be the maximum. Of course, the maximum would be, I don't know, $1 billion. I mean, there's not a dollar limit, but you did hear Ms. Lake say something. She said a lot of things that were important, but one of the important things she said was that the bond needs to be a realistic bond. I can put $1 million in the bond, and guess what? Mr. Arnold could not make $1 million. But because I know that, that would be like me saying no bond. But we're in this situation where the law says, you know what, Judge, you have to set a bond. I don't have to go along with the 10,000. I don't have to go along with the 100,000. I'll set a bond that I think is reasonable. And then time will tell if it's reasonable. If we move forward 60 days and Mr. Arnold is still in jail, then the bond I set was not reasonable because Mr. Arnold and his family weren't able to make it. And then we may have to have another conversation. You'd be notified, you'd be free to come here and give me an update on how those kids are doing and how you're doing. But today, I am required to set a bond where I think it's reasonable. But I want to make sure I put conditions on that bond that keep you and your family and friends feeling as safe as you can. And it's not perfect, I get that. But I'll certainly make that part of the bond, okay? Thank you for being here. Good luck with the lantern lighting.
Thank you.
Thank you. Is there anyone else, Mr. Abate? Just Ms. Cloud.
Yeah, she was speaking on behalf of the family, and I forgot to mention to the board, as recent as January 11th of this year, Mr. Arnold was in an additional flight of jail, which is all on video. You can see him maneuver his way up the stairs and then stand up and walk and begin to punch another inmate over a disagreement about TV channels. And that's all on video from the jail as well as documents from the sheriff's department or shows the initial arrest.
Okay. Yeah, it shows Mr. Arnold actually walking.
He does.
Okay. Got it. Ms. Lake, you are the movement, so I want to make sure you get the last word here. Is there anything else you want to add in connection with your petition that I set by now that we've exceeded the 90-day mark?
Your Honor, I would just ask, I'm still having trouble hearing Mr. Abate, and I did have trouble hearing the state's witness. Would you kindly indulge me and tell me what concerns Your Honor has, and I'll be happy to address them.
I'm going to set a bond. I am concerned that Mr. Arnold is more mobile than you portray him or he portrays himself to you. But that doesn't mean he's not going to get a bond. I just think that there is, and I've already said that. It's concerning to me that he has once again gotten into some affray at the jail. It makes him seem much less passive than he looks right now on the screen or that we've described him as. But again, unless someone brings new charges against Mr. Arnold for fighting in the jail or this or that, that's just a reason for me to be concerned, but not a basis to say no bond. That's it. The words from Ms. Cloud were very powerful and they were moving, but they relate much more, as you indicated in your objection, to the impact of Mr. Allison's murder on his family. And that is never to be discounted, but it's also, that's not a do you grant bond or not grant bond, unless there was some evidence, of which I have none, that Mr. Arnold was interacting with his family in any way. Of course, he must not do that. So you're welcome to add anything you want, but I didn't hear anything that you need to rebut. In some ways, it was more of the same, another fight in the jail, and then it was very powerful from Ms. Cloud, and important for me to hear it, but that's not directed so much at the factors of bond, as you pointed out, as it is just helping everyone understand that this is something that even 227 days later continues to very deeply affect Mr. Allison's extended family. Were you able to hear all that?
Yes, Judge, thank you. I'll leave it to my apologies if I misrepresented Mr. Arnold's mobility. My understanding is that that it comes and goes, that he does have limited mobility in his left side, but that some days are better than others.
I don't think you misrepresented anything. You're getting to know your client, and your client is whoever he is, and that will come out as time progresses. All right. I am required by law to set a bond in Mr. Arnold's case, I believe, based on everything I heard today. Again, I don't have the complaint in front of me, so I can't break this dollar amount out across the counts, but I will do so because Ms. Nelson, a litigation manager, will put this bond order together. The bond order will indicate that I'm required to set a bond. The total bond amount will be $60,000. That will be through the sheriff's 10% program. Mr. Arnold will be subject to pretrial supervision. He will be required to live at that address in Rex, Georgia. And let me make sure that's what's in the system. It's not got a Jonesboro address. So Ms. Lake, could you tell me that address in Rex, Georgia? Because that's going to be written into the bond.
Yes, Judge. One moment, please.
Sure. Ms. Gaines?
Sorry, Judge, are you ready? Are you?
I am.
Would you like me to read the address?
Yes, please.
Okay. 6652 Bank Creek Drive. And that's in Rex.
You have a zip code?
No, Judge. Let me Google it real quick, see if I can get one for us. Okay. And Judge, I'm sorry, 6652 Bent, B-E-N-T, not Bank. Bent Creek Drive. And that's Rex, Georgia, 30273.
Okay, thank you. So that's another condition, that Mr. Arnold will reside at that address in Rex. He will be outfitted with an ankle monitor that the county will pay for. He will be on house arrest unless and until Ms. Lake provides documentation that he has gainful employment that would require him to leave the house. The only exceptions for leaving the house would be medical care and coming to court. Medical care and coming to court, you can leave Bent Creek Drive. Otherwise, that's where you are. And you also will stay out of Fulton County, except for medical care and coming to court. And finally, no contact with any members of Mr. Allison's family, and no contact with any of the witnesses in this case. And that would be contact, of course, by Mr. Arnold. It doesn't restrict Ms. Lake or any of her colleagues from contacting any of these people. Mr. Arnold needs to have no contact, direct or indirect, with any of those people. Mr. Abate, any other conditions that you were hoping to see on the bond? Ms. Lake, any other conditions or concerns about any of the conditions that I did set?
Judge, I do have a question. I heard 60,000 through with the 10% option through the sheriff's program. Did you also say something about pretrial supervision?
I did.
Okay.
So he'd be subject to pretrial supervision as part of the 10% bond that he would post.
I understand. Thank you, Judge.
You bet. And Mr. Arnold, if this is a bond amount that proves unattainable for you and your family, Ms. Lake will get your case back in front of me But I asked Ms. Lake to refrain from filing a motion to reconsider for at least 30 days so that the family does have a chance to see what resources it can draw up. And we'll revisit it after 30 days if we need to. It may well be that at or around that point, the case is indicted, and then I'm no longer the one who would be the one to approach unless, out of coincidence, the case gets assigned to me after it is indicted. Ms. Lake, anything else on behalf of Mr. Arnold?
No, Your Honor, thank you. And I do expect that once it's indicted, it'll go to Judge Barwick since she's got an open indicted case with Mr. Arnold.
You're right. Lucky Judge Barwick. That's exactly where it will go. Okay. Mr. Abate, anything else on behalf of the state? There. All right. Ms. Cloud, thank you for being here. I appreciate it.
Good morning, Judge. The state and I make a quick announcement on Mr. Bass.
You may in just a moment.
Thank you, Judge. May I be excused?
Yes, ma'am. Thanks for joining us.
Take care, Judge.
All right. Ms. Wood, you're back.
Yes, Judge, I am.
Great. Do you have an announcement on Mr. Arnold?
I do, Judge. So we have decided to waive indictment on this 20 CP case. I sent that over to ADA Charles during our breakout session, and I think she may just need some time to go get that filed. And yeah, we're ready to move forward, Judge.
Is that something we can do today or?
Yeah, I'm gonna do it today. Another.
Great. No, that's fine. I just wanted to get the update. So we should keep Margio Arnold on the call because we may do something today. All right, great. All right, then let's go back to position one, Mr. Bass. Do you want me to loop Mr. Bass in?
Yes, if you don't mind.
I am happy to do that. Let's see if he has stuff around.
Looks like he's on the top right screen.
Yeah, mine looks a little different. Mr. Bass, you there?
Yes, Your Honor.
Fantastic. Let me make you big. There you are. All right. So, Mr. Bass, your lawyer, Mr. Patterson, was talking with the prosecutor while we were handling some other things, and it sounds like they got an announcement.
Yes, Judge. Yeah, we had filed a bond hearing, but the state is not prepared because the victim could not be here today. Secondly, we have reached a potential resolution in this case. The state is going to email me all the paperwork and the terms of the agreement today. And I'm going to go to the jail this weekend and present that to my client. We both respectfully ask that this case be put on your Tuesday calendar for a potential final resolution.
Do I have a Tuesday calendar?
You do,
Everyone's not here. So even though I'm the one with the name placard, I actually don't control my calendars, but let's see if there's someone on yet. Ms. Nelson, are you back?
Yes, Judge, I am. And yes, we do have a calendar on Tuesday.
Is it a calendar where Mr. Bass could be brought? Well, we're not bringing people over yet. So how is Tuesday working? It's not our Zoom calendar.
Well, if we're not transporting next week, then those cases will have to be rescheduled if we're not bringing inmates.
And what I was going to suggest is I go get him to sign all the paperwork at the jail, and then he can be on Zoom and do his plea over Zoom.
So that's a great idea if we can pull it off. Unfortunately, we have Zoom far less frequently than we had inmates in person. Every Tuesday, is my day to get inmates in person. And I may be misremembering as to how long we've put bringing inmates over on hiatus. I don't know the answer to that, but let's please put Mr. Bass on our Tuesday calendar. And then Mr. Patterson, we will keep you, I don't want to make you come down here if the reality is we can't get Mr. Bass here in person or virtually. I'm pretty sure it won't be virtually unless a colleague isn't using her Zoom, all her Zoom spots, in which case we'll borrow some and we can get Mr. Bass that way. But Tuesdays for us are in-person days, in which case Mr. Bass will be right here with you. So we'll keep you posted, but let's say tentatively, we will see Mr. Bass on Tuesday. If that doesn't work, we will make it as soon as we have another virtual day. And I know you're a busy guy, but you'll figure out a window on that day, hopefully, where you could plug in. So maybe we do Mr. Bass at 11 rather than at 9.
Absolutely.
But just look for communication from Ms. Nelson about that situation.
That would be fine, and the state is going to email me all the paperwork after she talked to the victim.
Yes, sir. Just to give you guys a full picture of what is happening. When I spoke to the victim, our victim is disabled and was fine, so she's not joining us by Zoom. Has to be in person, but that also depends on the caretaker who's also elderly. So it's a situation that when I spoke to her about the initial bond presidency was supposed to be in person, but she was not able to make arrangements. But I also don't have to do for this. Our office will transfer. She doesn't want to be present.
So that's good to know. All the more reason that we'll want the two lawyers and Ms. Nelson to coordinate, because we don't want to bring Mr. Bass over if we can't have the alleged victim here who's got a right to be here. So a few moving parts, good to know. Step one would be for Ms. Charles to get all this info to Mr. Patterson so he can do his due diligence and confirm with his client, this is the way you have to sort things out. And then step two will be making sure that whatever date we set, and it will be soon, no one's interested in delaying this, is a day where we can have Mr. Bass present virtually or in person and the alleged victim here in person. So just please coordinate with Ms. Nelson. She'll make it happen. Just, it's not, unfortunately, like the good old days where we snap our fingers and that's the day we'll do it. We are somewhat constrained. Mr. Bass, did you follow all that?
Yes, Your Honor.
Okay. So Mr. Patterson is going to be coming to see you after he gets more paperwork, so you two can have a heart-to-heart about how to move forward with your case. I'll note that it's a case from 2.5, 3 years ago. So it is definitely time to sort something out. And then we'll figure out if that's going to be next Tuesday or sometime close to that when we can get you back into court, either in this way, virtually, or actually in person because you get transported over, okay?
And will you let him know that I'm coming to see him this weekend, Judge?
Yeah, Mr. Patterson will see you this weekend. He's coming to Rice Street. I can't tell you Saturday or Sunday, but you'll know because they're going to bring you to the lawyer booth and you and Mr. Patterson will talk, okay?
Yes, sir.
All right, sounds good. I appreciate everyone coordinating on this one. It's a complicated one, but it sounds like it's important to get some closure on. Thank you, Mr. Patterson. Yes, sir. All right, Mr. Bass, you're good to go. Thanks for sticking around.
Yes, sir. Thank you.
Mr. King, you're here partly because you missed me, but mostly because you wanted your super fancy all leather bag. I'm gonna go get that once we figure out what we're doing. Unless you were here for other stuff.
I do this.
Okay. Can tell. So write this down. All right, so Ms. James, we can't do yet because Mr. Fortis, we now know which Scott it is, will be back. Mr. Arnold, we've got some paperwork to take care of, but Ms. Charles can do that when we take the plea in Williams. Wallace, Myron, why did we not do, oh, is that your case, Ms. Wood?
It is, Judge.
And is that gonna just be a waiver of arraignment, so we can knock that one out and he can be on his way?
Correct, Judge.
Great. Mr. Myron is in what Booth. Anyone know?
I think there he is. He's in 5 South, Judge.
5 South. All right, let me activate 5 South. Did he wave his hand? Is that how he did?
I was like scrolling through looking for him.
And ADA Asia Basic for the state on this case, Your Honor.
Great, thank you for being here. It's always a surprise. I can't tell from these charges, but that's great. All right. Can you hear me, Mr. Myron?
Yes, sir.
Fantastic. Good morning to you.
Good morning to you too.
All right, there you are. Now you are spotlighted. So, Mr. Myron, you have been indicted for aggravated assault and carjacking and battery. The assistant district attorney handling your case is Ms. Beza. She's on this call. And your lawyer is Ms. Wood, also on this call. And I think what we're going to do is just handle arraignment today. Your case is a little older, but there was a bench warrant for you. And that's why you got scooped up recently. Ms. Wood, is Mr. Myron waiving arraignment and entering a not guilty plea at this time?
Yes, Judge. And if I just may add, the bench warrant stems from he was actually incarcerated elsewhere. And I believe he was brought directly to Fulton when he was released in December. So I just want to let the court know that information.
Okay. Pulling up his case right now. That's a pretty slender file. I trust he had a bond. It must have been when it was an unindicted case, because it doesn't say anything about bond in the docket. It just has bench warrant, unless it was a direct indictment, in which case never got a bond. But today, narrow focus. It sounds like you'll fill out the necessary paperwork, Ms. Wood, to waive arraignment and enter the not guilty plea. That means, Mr. Myron, that we'll get a scheduling order out. Ms. Beza will ensure that all the discovery she has gets to Ms. Wood, so Ms. Wood, can talk to you about the state's evidence, and we will go from there. Ms. Beza, this is an older case, so you are newer to it. Do you have any sense as to how complete the state's file is?
And so it looks like we have I have to order the body camera, but we have the paper evidence, the digital evidence I'm going to have to order, and I can get it to Ms. Wood next week. It doesn't take long. The turnover is not long. Okay.
Ms. Wood, anything that you can sense early on that may be problematic with discovery? Assuming Ms. Beza is able to get everything she just described.
No, Judge, I do have the police report, and so I'll just get with her when she gets the body camera and anything else that's outstanding.
Okay.
911. Yeah.
All right. Mr. Myron, do you have any questions, sir?
No, sir. Yes, sir. The case is older, and I was in prison at the time, and I put in me and my lawyer, that the case that I had in the Cobb County that I went to prison for, she put in for this case and tried to get it resolved out before I went to prison. So I would have to get out and come back up here. And all I'm asking is that now that I'm back up here, I'm not understanding how I get indicted with.
Mr. Wallace, I don't mean to interrupt you, but we're gonna go back over all of those details. Once again, I'm gonna come see you next week, okay?
Yes, ma'am.
So, Mr. Myron, first of all, is your first name Wallace or is your first name Myron?
First name is Myron.
Okay, so they indicted you backwards. You are Mr. Wallace. You're indicted as Mr. Myron. So I'm sorry if I called you Mr. Myron. Mr. Wallace. Ms. Wood's going to come visit you. She will talk about, one, most importantly, the case, but two, also important, this whole situation about you already being in custody and missing court. And she may well get you back in front of me real soon to talk about bond. And we'll certainly do that if she and you think that's appropriate. Today, I just want to get things moving again because you're sitting there and this is an older case. I want to make sure it reaches a close, whatever that close may be. So expect a visit from Ms. Wood when she's got some of that discovery to come talk to you. And then I will see you either because Ms. Wood's filing some motions on your behalf or because we need to talk about something else, okay?
Yes, sir.
All right, thank you.
Thank you. Are we done?
You and I are done. You're free to go.
Your Honor, that concludes my business. Ms. Wood and I had a plea on another case, but I believe the defendant is not ready to take it today, so may I be excused?
Almost. Let me understand which one that is, and let me make a note. So Ms. Wood, you'll get the waiver of arraignment to Ms. Nelson?
Yes, Judge.
However you guys do that.
Yes, Judge.
All right. All right, Ms. Beza, which case are you talking about from the calendar?
It was not on the calendar. Ms. Wood actually emailed Ms. Nelson to add it to the calendar.
Right.
Okay. But it's not happening today, so all you're doing is tempting me by telling me the name of the case.
It was a walk-in, Judge.
Okay, all right. Then maybe that will happen some other time. We do have our trial calendar coming up soon, February 2nd, and currently we're told we'll be able to have jurors by that date. So hopefully folks are getting ready there. Yes, Ms. Beza, you are free to go.
Thank you, Your Honor.
All right, why don't we handle Mr. Coleman? And then we'll take the plea in Williams so that you can do the work on the other Arnold. So is Mr. Coleman in one of the booths? Okay. I'll let Ms. Nelson work with you guys because I've got a add-on calendar that has Mr. Coleman on it. My calendar, of course, is older, so it says 1 North. But we need to get him into a booth. We got to figure out who his lawyer is going to be. So I'm going to go get something for Mr. King. If Ms. Nelson and folks at jail can coordinate on Mr. Coleman, and then we'll take the plea in Williams. So if you want to get Mr. Williams, fine doing it at the table rather than the podium.
Either one's fine with me, Judge.
Up to you. And then I guess if you could get Mr. Kabate, I assume he's doing the plea for Mr. Williams.
Yes.
Great. I'll be right back.
Okay, what do you need help on scheduling, team?
We need to get Mr. Coleman into a booth. You're out.
Okay.
All right, I'm going to move Ms. Wood and Mr. Arnold. That you need unmute. You can get that unmuted. Mr. Arnold, you there?
I'm here, Judge.
Fantastic. I'm going to put you back in a breakout room with Ms. Wood. She said she wanted to talk to you one more time. We're taking a plea and then we'll get you back up and take care of your case, okay? So you're going to go back into that fun room you were in. See if I can do that.
She got them shoes on. I like it.
Judge, want me to approach with the plea?
During the course of that, yes, make sure that's going in there. Great. I'll be right back.
Any questions for me?
Is the Cobb County Jail on the call right now? Somebody from Cobb County Jail?
You were in the 10%, right? Yeah. I gotta go to the jail. Back to jail. I'll get a copy or I'll ask them. The copy. Is it in your name or in your mom's name? I would listen. I would go with you. Go with your sister. Hey, Zach. What? there's in me, I got a screen. But there's no, they have to pay. We may have to do that again. Modification. I just need to do it today. Yeah. And I need to. Right, yeah, I'm sorry. Thank you, Judge.
Yeah, that's.
Have a great day. I appreciate it.
It's initials on it or something like that.
Yeah, it does have my, that's all. So, thank you, sir.
Take care. All right, is your microphone on green or red?
Green.
Green, excellent. Ms. Rivers, can you hear us?
Yes, Judge, I can hear you.
We are going to take a plea now, I believe, in a case that is not on today's small calendar, it's on the trial calendar. Let me find it. Position 8. All right, let's go on the record. This is indictment 19 SC 172644, State versus Quentin Williams. Mr. Williams is here in court represented by his lawyer, Mr. Melnick. The state is represented by Mr. Abate. Mr. Williams is a co-defendant in a case that was tried. 2 defendants went to trial and were found guilty of aggravated assault in a murder case. Mr. Williams was severed out, did not testify, and didn't really have a role to play, but then he appeared prominently on video several times in the trial. It's charged with tampering with evidence, and it's my understanding, Mr. Melnick, that Mr. Williams is prepared to enter a plea today.
That is correct.
All right, Mr. Williams, the way this is going to work is that in a moment, Mr. Abate is going to put you under oath. Once you're under oath, he's going to ask you a whole bunch of questions that are meant to make a really clear record that you understand your rights as a defendant, you understand the impact of the decision you're making today, and it's real important that you answer all his questions truthfully. And it is equally important that you let Mr. Melnick or me know if you've got questions of your own. If someone says something that you don't understand or is different than what Mr. Melnick told you, then we should stop. We need to make sure that you're following what's going on. Okay? You do that? All right. And everyone needs to talk into the microphone because our court reporter is far away. She needs to hear you through the microphone. All right, Mr. Abate, when you're ready.
Thank you, Judge. Mr. Williams, please raise your right hand. You solemnly swear to affirm the testimony about the matter pending before this court will be true, the whole truth, and nothing but the truth, sir. Thank you. And if you'll do me a favor, speak real loud in the microphone, state the true and correct legal name for the record. And Mr. Williams, are you at this time taking under the influence of any alcohol, drugs, or medicine? Is there any medication that you take on a daily basis that you didn't take today? Yes.
I don't hear him.
And how old are you, sir, and how far have you gone to school? Okay. And where'd you go to school? Okay. And are you able to read, write, and understand the English language? Okay. And do you understand?
No, I'm not, excuse me.
Okay. Are you able to, do you understand that you're charged with the following offense? Tampering with evidence and indictment number 19 SC 172644. Okay. And do you understand you have the right to plead either guilty or not guilty to these charges? If you pled not guilty or remain silent, you can receive a jury trial. And have you given an opportunity to go over the waiver of rights form with your attorney, Mr. Melnick? Okay. Did he go over each point with you on that form about what rights you were waiving? Okay. And then on the back of the form, did you sign next to your attorney that you understood what attorney, Mr. Melnick. You need, are you satisfied with the services? And Mr. Melnick, do you waive formal reading of the indictment?
We do, yes.
As well as do you waive any and all defects in the indictment, including any with respect to your client's name?
Yes, we do.
And Mr. Williams, as your attorney, Mr. Melnick advised you of the minimum and maximum sentence for the single charge you're pleading to. He advised you the minimum is 1 year and the maximum is 10 years. And you understand this is a negotiated plea of guilty, non-negotiated plea of guilty.
No, it's a negotiated plea of no liquor.
Sorry.
Sorry.
You understand this will be a negotiated offer that your counsel and state will present to the court, but the court is not bound by the offer, the joint offer from your counsel and the state. You understand that negotiated offer is 5 years on probation. Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal court? Okay. And do you understand that if you are not a United States citizen, a guilty plea will affect your immigration status and will result in deportation regardless of any advice given to you by your attorney or anyone else? Okay. You understand that you waive any and all defenses by entering a plea of guilty here today? And you understand that by pleading guilty, you're giving up or waiving the following rights: the right to a trial by jury, the right to remain silent and to not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or court appointed if you are unable to afford an attorney at the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and to compel the production of evidence, and the right to have the charges against you proved beyond a reasonable doubt by the state of Georgia, and the right to appeal if convicted of these charges or discharged after trial. You understand that you are waiving or giving up all of these rights by pleading guilty here today? Has anyone forced, threatened, or promised you anything to get you to enter a guilty or nolo plea here today?
No, sir.
Okay. And how do you plead to the charge of tampering with evidence in indictment number 19 SC 172644? Okay. And are you pleading nolo because you believe it's in your best interest to do so? And if this pleas are freely and voluntarily given with full knowledge of the charges against you? Okay. Do you understand that you may only have a limited right to appeal this guilty plea or nolo plea here today? And do you understand that you only have 4 years from today for a felony charge to file what's called a habeas corpus petition challenging this plea? Okay. Your attorney went over with you your rights as it pertains to a habeas corpus petition. Okay. And Your Honor, had this case proceed or had the case proceed to trial as it pertains to this defendant, the state would have been able to prove beyond a reasonable doubt that on July 12, 2019 was approximately around 2:15 a.m. At the Buckhead Loft, which is located in Fulton County here in Buckhead at 2101 Tula Street, Atlanta, Georgia. This was a club where the defendant and his friends, Tyree Blige and Xavier Head, were leaving the club. Right behind them, the victim, Mr. Solomon Smith, and his friends were also exiting the club. At the time that both parties were exiting, the group or the friends in which Mr. Williams was with, there was a fight between a female and a male, in which Mr. Solomon Smith witnessed, and at that point got involved by trying to break it up or see what was going on, along with the females that Mr. Smith was with. At that time, the fight had kind of dispersed, or the argument had dispersed. But some of the friends that Mr. Williams were with kind of re-engaged with some of the female Smith was with, and their gunshots began to be fired, and Mr. Smith was hit multiple times and was killed as a result of being shot. After the shooting, you can see Mr. Tyree Blige, who Mr. Quentin Williams was with at the club, begin to pick up shell casings. You see Mr. Williams on the video doing the exact same thing, where he approximately bends down to pick up what the state would submit to the court or jury for shell casings based on the evidence that remained when members of the Atlanta Police Department showed up. But Mr. Williams was wearing very distinctive clothing. He had knee pads. Yes, black pants with what I would call knee pads as well, white over the area of his knees, where you can see him initially in the video walk in, where he was identified as Quentin Williams. You can see him in the same outfit, picking up what the state would contend the evidence would show beyond reasonable doubt with shell casings. Based upon all of that, Your Honor, the state would have been able to prove that beyond reasonable doubt. Mr. Williams does have, I believe, one felony conviction out of Clayton County, but he took it, it was a burglary, which he took under first offender. My understanding, he's still on probation for that at this time, but it's not been adjudicated. Has been revoked.
Okay. Thank you. Good morning, Ms. Toussaint.
Morning.
How are you?
How are you?
I'm well. Do you have other Georgia criminal history for Mr. Williams, or just that Clayton County
Just
case?
the Clayton County case, and it looks like it ended in February 23rd, 2019.
Do you think it's closed?
In active probation up and on.
Okay.
It's, Judge, I'm sorry, I didn't mean to interrupt.
It's okay.
It's non-reporting. It was a 10 to serve 3 that he received sometime in 2015. I don't remember the exact date. He had been in for a little while, so we got a lot of time toward that sentence. So my calculation was that it expires in early 2024. And so that is the primary reason we're asking you to accept it as a middle of plea, because otherwise he would stand to have that time revoked in Clayton County. There are other reasons I can get into if you need me to, but that's my understanding of what is happening with that.
Okay. But either way, it's not active probation. Like,
he's been on non-reporting for quite a while.
If he was on non-reporting in our system, it would show non-reporting. But as far as what we see in here, the offender is not on active supervision through state here. He could be on a misdemeanor probation.
okay. Got it. All right. Well, either way, that may still be out there, and that explains in part the no. Thank you. Mr. Melnick, what do you want to tell me about Mr. Williams and his case?
So, Your Honor, just to give you some personal history, the only other conviction that he has is the case out of Clayton County. Since he has been out of prison on that case, which has been quite a while, he has been working pretty steadily. His family has a business, a florist business, a storefront, and so he works delivering flowers for them and doing other things for the business, as well as he has a side job painting apartments right now. He did complete his GED while he was in prison, and this case has actually had, he's looked for other opportunities for employment in this case, and the curfew and such has had a pretty significant impact or impediment to it as far as doing all of that. He has a 3-month-old child that is dependent upon him for support, and he's actively involved in his child's life. I interviewed Tyree Blige, who was out there with Mr. Williams during the course of these events during this incident. Mr. Blige told me that Mr. Williams was not picking up shell cases. Mr. Williams, so I'm not trying to try to case, obviously.
It's been tried.
Yeah, but you can kind of see Mr. Williams running away from the scene in one of the videos. It actually appears that somebody is shooting at him as he's running away.
You say somebody, we were able to sort out who had guns. So would this have been?
It was Mr. Rivers.
Mr. Rivers.
It wasn't, and I mean, so anyway, and Mr. Williams was wearing a somewhat unusual pair of pants that evening that didn't have pockets. So he dropped his phone and his driver's license, and he was trying to find them in the parking lot in the aftermath of this, very terrible series of events. So yeah, I think it's pretty conclusively established that he wasn't really involved in the melee at all. So he kind of just got caught up in everything else that was going on. He does deny that he was picking up shell casings. So that is another reason that we're asking you to accept it as a no. And that's all. That's all.
But Lige told you, look, I picked up some shell casings. Not Lige, he testified to.
Yeah.
But he said, I don't think Williams did. I don't know what he was doing. But your client has told you, this is what I was picking up.
That's exactly right.
Right. That's helpful. Appreciate it. Mr. Williams, it's your case. Anything you want to tell me? You have a boy or a girl?
I just have a boy.
The 3-month-old, what's his name? Capri? And does he stay with his mom, or does he stay with you, or he stays with you? Why not his mom?
We stay together.
So he stays with both of you.
Yeah, we stay together. That's why I was saying, for the perfect thing last 3 weeks ago, I work, and I got to work for a job in the morning.
Well, you're taking care of the curfew thing today. Capri's mother also works?
Yes, sir.
What does she do?
She's a manager at a hotel.
Fine. Well, Mr. Williams, I find there's a factual basis for your plea. That doesn't mean I'm telling you what a jury would do. It sounds like you have a good defense. I don't know what the jury would do with that defense, but if they saw it the wrong way, why are you still standing around there after there was a shooting, this and that? They could find you guilty. It's hard to know. They might believe you if you testify, they might not. Those are complicated things, but I get it why it's a no-law plea. I'll accept it as a no-law plea. I also find that your plea is knowing and voluntary. Voluntary means that, well, you're not happy to be sitting in that chair right now. You've decided that it's in your best interest to go forward with the plea. Is that correct? Okay, and a knowing plea simply means you've understood all the things we've been talking about. Is there anything that anyone has said today that you do not understand? Any questions?
Judge, he posted a bond through the 10% cash program through the jail. And I would ask, he was in jail from March 2nd of 2021 through, from February 2nd of 2021 through March 3rd of 2021. So I would ask him to be given credit for that time.
Okay.
But it was just a month, but it takes 1 month off probation. And so his question was about the 10%, and I just told him, I've already told him.
Yep. You should get it. I think there's a little fee, but otherwise you get all of it back.
Yeah.
All right. I'm sentencing you pursuant to the probation. Well, let me go back to the question. Other than the question you just asked Mr. Melman, do you have questions about anything? I'm sentencing you pursuant to the Probation Options Management Act. And what that means, Mr. Williams, is that while you're on probation, you will be for a few years. If you have a small or technical violation, you and probation deal with that. You don't have to come back and see me. But if you get arrested for something more serious like that, that comes back to me. Mr. Abate, was there any victim impact statement from Mr. Smith's family or anyone who wanted to be heard? Mr. Malik, do you waive any issues that might arise from the fact that we are working off a copy of the indictment?
Yes, I waive it.
You do waive that. Great. Mr. Williams, I'm going to sign electronically the indictment indicating your no-law plea. Do you authorize me to sign on your behalf?
Yes, sir.
Okay. Mr. Mellon, can I sign for you?
Yes, sir.
And Mr. Abate?
Yes, sir.
We also have, I don't know if we've collected that yet. Mr. Williams, there was a long form that you and Mr. Melnick went over that covered a bunch of the things that Mr. Abate asked you about. We had put your initials next to lots of things.
Yes, sir. Yes, sir.
Did you initial everything that applied to you?
Yes, sir.
And you signed it? You had a chance to ask Mr. Melnick any questions about it? And Mr. Melnick, you signed this?
Yes, sir.
Great, we'll make this plea of guilty, plea of no form, with purple ink, part of the record. And that is it. I think I will follow the recommendation, Mr. Williams, and sentence you to 5 years of probation. You'll get credit for the little bit of time you were in custody. If you do well on probation, meaning you stay out of trouble, you report, do all the things, it sounds like you'll have no trouble doing. Probation's gonna wanna make this non-reporting real soon, sort of like what's going down in Clayton. So that's your incentive, is to just do what they tell you to do, show up when you need to show up, do all that kind of stuff. And they may even come back and say, can we close this case a little early? It's a non-violent offense, it's associated with something real violent, but that's not you, that was lives, that was Ed. So, that's encouragement to you to, knock out this probation stuff early on, and then they're gonna wanna get out of your hair if, you aren't being a problem, because they have folks who are a problem, okay? We do need to get some reporting instructions. Do you live in Fulton County?
Yes.
Okay, then we need to get it on the record, or you can just talk to him? Okay, I think that's it. Mr. Abate, anything else in Mr. Williams's case?
There you are.
Mr. Mellon? All right, thank you both. Mr. Williams, if you would just, with Mr. Mellon, could decide, talk with Ms. Tucson. She just needs to get some address information, and she's gonna give you reporting instructions so you make your first meeting with probation, okay? All right.
Hey, Judge McBurney, Scott Fortis here. Wanted to let you know that I'm back. And also, if you would be able to put me in a breakout room with someone to discuss this matter.
Yeah, in a minute.
Okay, thanks.
Yes, Mr. Abate, we are good. You don't have a case, I think, for February 2.
Not anymore, no, Your Honor.
That's right, not anymore. Looks like Rooks is what we're looking at. These other things go away. Okay. And you're getting ready for Rules B for the 16th?
Yes, sir.
Okay, great, thank you.
I'll be sitting with this,
Okay.
So,
Judge McBurney.
they are bringing in judges next week, or jurors next week?
Hold on one second, Lieutenant. No, jurors come back, the 31st. So next
That's
week.
not next week. That's
Right, next week, no jurors. I'm not sure if we're bringing inmates over, but we'll see. But, currently the plan is jurors are back on the 31st, which would mean on the 2nd, I can do this trial.
Okay.
Numbers gotta cooperate.
Okay.
All right,
Thank you.
thank you, sir.
yeah.
Lieutenant, yes, ma'am.
I'm sorry to interrupt. Can we do Cobb County next? Sergeant Edwards has defendants in Cobb County that needs to be on the non-complex calendar, and they only have 2 inmates left. So she's trying to juggle them both, but they only have 1 computer.
Sure, we need to get Ms. Charles back in here. She left, so hopefully someone can track her down. Do we have Mr. Coleman in a booth now?
They told me they were putting him in the booth, Judge.
He's up there, okay, he must be waving his hand, I can't see him, but, is he in 1 North?
Yes.
Okay, all right, great, yep, there he is, 1 North, let's just need to know where he was. Write that down. 1 North. But yes, Lieutenant, we'll do Cobb as soon as we can get the prosecutor back in here. We can't really do much of anything. Mr. Fortis wants to talk to the prosecutor as well in connection with Ms. James's case. So I'm gonna sit tight right here and we'll put out a APB for Ms. Charles, get her back in here.
Receive, thank you.
Mhm.
Judge McBurney, are you on?
I am. Are you on?
I am. What's Miss Charles's first name?
Nalda, Nalda.
Okay, thank you.
You bet. And you wanted to talk with her, not your client in the breakout room. You wanted to talk with Miss Charles, not Miss James. Is that correct?
That's correct, Judge.
Okay. What will likely happen, since Miss Charles will be here in court, is that she'll step out and call you on her cell phone. You guys can talk on the phone rather than in a breakout.
That'd be fine, Judge.
Okay.
Thank you.
You bet.
Just overall, cases, if there's maybe notified, or the it's up to 32 weeks.
Judge McBurney,
Yes, ma'am.
did you want to go ahead and close those other booths where we don't need? That way we can kind of minimize.
Yeah, I'm happy to do that. I'm sorry, I don't know where our prosecutor is. I'm trying to track her down, but I'll close those other out. So we need one north, because I see Mr. Coleman sitting there. And then I guess we've got the gentleman in Cobb, which you want us to prioritize, and the young lady at, Union City. So everything else I'll close out.
Thank you.
Sure. Welcome back.
Your Honor, I don't believe I have anything left on the calendar. I was wondering if I could be excused.
Certainly. Let me just get an update from you. Do you have any of the cases that are set for February 2? Are those all Ms. Wood or private attorneys?
I do. I have Tamar Richardson.
Okay.
Miss Charles is going to speak with her supervisor today, I believe, about that case.
Okay. Great.
And then Mr. Griffin, I am waiting on an offer from Miss Beza. She did reject my offer of diversion, so I'm waiting, and once I hear back, I will take that to my client and see.
Okay. So those are at least in play.
Yes, I am working on it. Your Honor, I do have leave starting tomorrow up until the end of next Friday. We have a court calendar then. I will be giving Miss Wood my announcements, but I'm also happy to let you know if you'd like to know in advance. There's not going to be a whole lot happening on the cases that I have.
Okay, you can get that info to Ms. Nelson if you want in an email, and then she can share that with me and we can get it on the calendar. That'd probably be helpful. I mean, I don't know what the calendar is, but if there are people who shouldn't show up because you're not going to be there or nothing's going to happen unless it's important that we see them, we can save the system that extra step.
Will do. I will let Miss Nelson know what I intend to do on those positions. And then, Your Honor, just so that the court is aware, I still have not received the discovery in John Connor's case. I'm not asking for more time at this point, but if I'm in trial February 2nd, I may be, just because I'll be gone all of next week. And so I won't have an opportunity to review whatever is served when it's served.
And Connor is a Siri Patel case?
Yes, Your Honor. And she has been making her diligent efforts to obtain it. Apparently the detective was in an accident, I believe yesterday or the day before.
Oh, okay. All right. Well, then that may slow things down, but we'll get an update. We'll get an official update from her. Okay. If you don't mind staying on for 1 second, I want to figure out what we're doing with Mr. Coleman, because he's just on this for purposes of sorting out representation.
Sure.
And I don't know if that would be you or Ms. Wood, if it's going to be anyone from your office. Then we'll turn to Mr. Arnold, and you are free to go, Ms. Patel. So let's get Mr. Coleman from North. That's me. All right, Mr. Coleman, can you hear me?
Yes.
Good. There you are. All right. So you had Mr. Ford as your lawyer. You've had someone calling my chambers and being most impolite with my staff. You're going to want to have that person knock that off if that's not appropriate. And we need to figure out who is going to represent you in this case, because it's not Mr. Ford. Are you planning on hiring someone, or do you need me to appoint a lawyer to represent you?
I think I had appointed someone. I mean, it was someone supposed to be, I guess, public defender. Supposed to be.
That's how it would work if you qualify. At some point, you or someone close to you has some money, and Mr. Ford was retained to represent you. He's out. I entered an order a while ago getting him off the case. And so you currently don't have a lawyer. If you are financially able to hire one, then you need to get a lawyer. If you are not financially able, since you've been sitting in jail for a while, 105 days now, then I am happy to appoint one of our expert public defenders to represent you. But I just need to know where you're heading on that. Are you planning on retaining someone, or do you want me to line someone up?
If it's okay, if you can line someone up, it would be today.
It would be actually right now, because I have both the public defenders on this call right now. I just wasn't sure. Your case ends in a 9. So would that be Ms. Wood or would that be Ms. Patel?
Your Honor, that'll be my case.
Ms. Patel.
All right. If you don't mind, if I put you and Mr. Coleman in a breakout room, do you mind talking with him real briefly? We don't need to do anything more than that. It may be that there's a conflict. It may be that you learned that Mr. Coleman has $100,000 in his bank account, so you're not in a position to represent him. But if you could just have that conversation with him, and if you are able to represent Mr. Coleman, if you would just share that fact with Ms. Nelson, then both you and Mr. Coleman will be free to go after that conversation.
Yes, Your Honor.
Great. So, Mr. Coleman, I'm going to move you into a breakout room. You'll be able to speak privately with Ms. Patel. No one can hear what you guys are talking about. She'll let you know her role in this, and you can let her know what you want to have happen going forward, okay?
Okay.
Let me see if I can make this happen. One more. All right. Yep, fantastic. All right, we are ready, Cobb County. Sorry to keep you waiting so long. No, I don't. There they are, Cobb's. All right, so Mr. Arnold, you need to unmute. I don't know if you can do that or if one of the deputies there can unmute it. Great, he's on. So Ms. Wood, what are we doing with Mr. Arnold's situation?
Judge, we are going to handle his probation revocation today, as well as the new case. We did waive indictment on that. Ms. Charles had given us a reasonable offer for a global resolution, and it is Mr. Arnold's desire to move forward in a non-negotiated fashion for these cases.
Okay, then let's get on the record. Ms. Rivers, you ready to go?
Yes, I'm ready.
Great. This is position 5 on our calendar today. It is on the probation revocation side, 17 SC 153471. We also have a 20 CP 191858. Has that been accused, Ms. Charles?
It's been filed with the office. I don't get to see it, honestly.
Okay, so I'm gonna ask you to move to the microphone and turn it off. There you go, perfect. You relocate. So the accusation's been submitted to the clerk's office.
I don't know either, but it hasn't shut up there, honestly.
That's okay. We can still take the plea. It will get an SC number and this will govern that. So, Mr. Arnold, are you ready to go forward?
Yes, Your Honor.
Great. Do you waive your right to be present in court today?
Yes, Your Honor.
You also have a right to have Ms. Wood by your side for this plea and revocation. You guys have already had 2 conversations, breakout rooms, and we can keep doing that. Are you comfortable for now moving forward with Ms. Wood at her remote location and you at the Cobb County Jail?
Yes, I'm comfortable.
Okay. If at any point you need to speak to her privately, let me know, okay?
I understand.
Great. Ms. Charles is about to put you under oath. Once you're under oath, make sure you answer all her questions truthfully and completely, okay? Okay?
Yes, Your Honor.
All right, and you'll let me know if you have any questions?
I did have questions, but I was just gonna ask.
I'll be right now, but if while we're having this conversation, if someone says something that you cannot hear or you don't understand, you'll let me know?
Yes, Your Honor.
Great. Okay, let's get started, Ms. Charles.
You wanted me to continue with my question? You asked me to have a question.
Yeah, what's your question?
I was trying to see, was it eligible or was it able by any chance that I could get a program or drug court?
So I don't know if you and Ms. Wood already talked about that. I don't know what conversations you all had. Drug court is always a possibility if you meet the criteria that you suffer from a pretty serious addiction, and that explains why you've been arrested before. we don't need to sort that out today. I could make it part of your sentence that you go through drug court intake, but why don't we work through what we're gonna work through, and then you should ask that question again when we get a little further along, okay?
I understand, Your Honor.
Great. All right, Ms. Charles.
Mr. Arnold, could you please raise your right hand? Do you swear or affirm that the testimony you shall give in the matter currently before the court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Can you please state your true, correct, and legal name for the record?
Can you repeat the question?
Can you please state your full name for the record?
Kamagio Demir Arnold.
Please spell Kamagio.
AEMARGIO Arnold ARNOLD.
Are you at this time taking on alcohol, drugs, or medication?
Can you repeat the question one more?
Time under the influence of any alcohol, drugs, or medication?
No, ma'am. Not at the moment. No, ma'am.
Is there any medication you would normally take that you have not been given today?
I couldn't understand the question. Someone's in the background. Can you repeat the question?
Is there any medication that you would normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
I graduated from high school, and I also attended. I got my high school diploma from South Carolina Educational Complex, and I also attended Emory Pipeline.
How old are you?
I'm 27 years old.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you are being charged with the following offenses? Possession of cocaine with intent to distribute under OCGA 1630-30B.
Yes, ma'am.
Possession of MDMA with intent to distribute, OCGA 1630. Possession of marijuana with intent to distribute, OCGA 1613-30J. And possession of a firearm by a convicted felon pursuant to OCGA 1611-131B.
Yes, ma'am.
You understand you have the right to plead either guilty or not guilty to these charges, and if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer, Ms. Woods, about all of the facts and circumstances known to you regarding the charges, the accusation, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss the case with your attorney?
Not at the moment.
Are you satisfied with her services?
Can you repeat the question?
Are you satisfied with Ms. Woods' services?
Am I what?
Are you satisfied with her services?
Yes, ma'am.
Counsel, do you waive formal reading of the accusation?
So waived.
Do you waive any and all defects in the accusation, including any with respect to your name?
So waived for purposes of this hearing.
Mr. Arnold, have you been arrested on these charges?
You said, have I been arrested?
Yes, were you arrested on these charges? Do you remember being arrested? Your Honor, the state is unaware of any outstanding warrants related to these charges. Mr. Arnold, do you or your attorney, do you know of any outstanding warrants related to these charges?
No, ma'am, not that I know of.
And has your attorney advised you of the minimum and maximum sentences for each charge you are pleading to?
Yes, ma'am. Yes, ma'am.
Your Honor, under the count one, possession of cocaine with intent to distribute, minimum 5 to 30 years, maximum. Possession of MDMA with intent to distribute, minimum 2 years, maximum 15. Possession of marijuana with intent to distribute, 1 minimum, maximum 10. And possession of a firearm by a convicted felon, minimum 1, maximum 10 years. Mr. Arnold, do you understand if you are sentenced as a recidivist under 1710(7)(b) or C, you will be required to serve the entire portion of your sentence imposed without the possibility of parole? And that is true regardless of any advice by your attorney or anyone else?
Yes, she's sentenced as a recidivist, is that right?
Your Honor, that was your email.
You are gonna?
No, we're not going to receive.
Okay, all right, so don't worry about the recidivist stuff.
Okay. Mr. Arnold, do you understand that if your guilty plea is a blind plea, also called a non-negotiated plea, that the state may still recommend a sentence to the court?
Yes, ma'am.
And are you aware of the state's previous offers to you in an attempt to resolve the case?
Yes, ma'am. She told me.
And have you discussed this offer with your attorney?
Yes, ma'am.
And you understood that the state offered 10 years served to without some probation?
Can you repeat the question?
And she explained to you that the offer that the state would honor was 10 years served to with the balance of probation?
Yeah, with the balance of the probation?
Yes.
Yes, ma'am. 10 served, yeah, she told.
And do you understand that the court can impose any sentence authorized by the law, including a higher sentence than the recommendation by the state, up to the maximum sentence of each charge?
Can you repeat the question, ma'am?
Do you understand that the court can impose any sentence authorized by the law, including a higher sentence than that is recommended by the state, up to the maximum sentence of each charge?
Yes, ma'am.
Do you understand that if you enter a non-negotiated plea, you do not have the right to withdraw your plea once the sentence has been announced?
Yes, ma'am.
Do you understand that this guilty plea is permanently recorded on your criminal history?
Can you repeat the question?
Do you understand that your plea today, if you plead guilty, will be permanently recorded on your criminal history?
Yes, ma'am. Yeah, I just want to repeat the question.
And do you understand that this plea may be used in the future to enhance sentencing on any other conviction in this jurisdiction, as well as any other jurisdiction, including the federal courts?
Yes, ma'am.
Do you understand that if you're currently on probation, your probation may be revoked based on you entering a guilty plea today?
Say my probation may be revoked.
Right, and in fact, that's what we're gonna work through today as well. You are on probation in this older case, the 17 SC case. And one of the things we'll be talking about is what should the consequence of this new plea be on your probation?
Yes, Your Honor.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any government unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, I understand.
And do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, I understand.
Are you a United States citizen?
Can you repeat the question?
Are you a U.S. citizen?
Yes, I am a United States citizen.
Do you understand that there may be adverse or unfavorable consequences as a result of this guilty plea, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment?
Yes, I understand.
You also understand that by pleading guilty to a felony, if you receive, possess, or transport a firearm or use a firearm in a crime, you'll be guilty of a felony which may carry a sentence of 1 to 15 years in prison.
Yes, I understand.
Waive any and all defenses, including any mental health defenses, by entering a plea of guilty.
Yes, I understand.
Do you understand that if you were to go to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and to not incriminate yourself?
Yes, I understand.
Do you understand that by pleading guilty, you are giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or court appointed if you couldn't afford counsel, the right to the presumption of innocence, the right to testify on your own behalf or to present any other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, the right to appeal if convicted of these charges after a trial.
Yes, I understand that I'm giving up my rights. I understand.
And has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Not really, but I'm just ready to move forward. I really plead no, but yes, but you're correct.
So, are you saying you are pleading because you are, or is your answer no? You're pleading because you believe it is in your best interest to plead?
It's my best.
So, are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were to be convicted by a jury pursuant to McBurney versus Alpha?
I understand. Yes.
Mr. Arnold, how do you plead to the charges of possession of cocaine with intent to distribute, possession of MDMA with intent to distribute, possession of marijuana with intent to distribute, possession of a firearm by a convicted felon?
You say, how do I plead?
Yes.
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Can you repeat the question?
Is your plea of guilty freely and voluntarily given today with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that she may only have a limited right to appeal this guilty plea conviction?
Do I understand? What do you repeat the question?
So from today, from the day of the guilty plea, you have a limited right to appeal your conviction, which means you only have 4 years from today to enter a habeas corpus petition challenging the voluntariness of your guilty plea.
I understand. I'm totally familiar with the habeas corpus.
Your Honor, were this case that got proceeded to trial, the state would have shown that on or around May 15, 2020, officers of the police department were on patrol in the area of Jonesboro Road and the McDonough Boulevard. When the officers noticed that the vehicle had changed lanes without properly indicating and using the signal, officers stopped the vehicle and approached the driver. On their approach, officers noted a strong odor of marijuana emanating from the vehicle, both on the driver's side and on the passenger side. Mr. Arnold was in the passenger side and the rear passenger side of the vehicle. Officers detained all of the occupants and conducted a search of the vehicle. Officers asked Mr. Arnold for his ID and license, which he stated was in his bag on the back seat of the vehicle. While detained Arnold, officers proceeded to go into the backpack to receive the ID. Doing so, they found in the backpack multiple baggies containing 23 baggies containing 29 grams of marijuana each. Officers also found in the backpack a green bottle containing 12 grams of MDMA. In the backpack also was a black Glock 9mm with 41 bullets, 2 magazines, and also another shaving bag which contained another quantity of marijuana and 2 more small black bags of marijuana weighing approximately 25.8 grams. Finally, officers also found an Altoid container which contained 8.4 grams of MDMA. The fire was checked on, it was reported not to be stolen. However, on the check on his GCIC, officers know that Mr. Arnold had been previously indicted on 1/19/2019 in the case in Fulton County 17 SC 153 471 on the charges of possession of cocaine, MDMA, marijuana, heroin, and meth with intent to distribute. Mr. Arnold was subsequently transported to Fulton County Jail.
I didn't hear you say anything about cocaine. There was MDMA, there was marijuana, gun, a lot of
I said that down, Your Honor. There were also small baggies containing 8.6 grams.
Okay. Got it.
Mr. Arnold was charged accordingly. Your Honor, Mr. Arnold's criminal history is 2 prior felony convictions, a 16 SC 144179 for possession of marijuana in Fulton County in 2018, and 17 SC 153 471 for trafficking cocaine in Fulton County in 2018. And prior to me taking into this case, I was aware of multiple solve the case and offered me to the defense to have.
I'm sorry, Ms. Charles, I cannot hear you.
I'm sorry. Prior to today, there have been multiple attempts to resolve the case, and the offer was made to the defense to have a holistic resolution of the outstanding secret case to include the current pending probation case of 17 SC 153 171, where Mr. Arnold reduced 10 years to serve 2 with the balance on probation, and that would result in a holistic resolution of the case. As of earlier this morning, we had a negotiated plea. While we went on a break, Mr. Arnold decided to go non-negotiated. So our offer is no longer on the table. I would ask the honor to consider all of the facts and circumstances to close resolutions.
Okay, question, follow the last thing you said. At some point today, you thought Mr. Arnold and Ms. Wood and you were all on the same page.
Yes, Your Honor.
And then Mr. Arnold came off that page.
Yes, Your Honor.
Okay. The 10 to serve 2 was the page he came off of, or it was something different, but because he's come off that page, you're going back to the 10 to serve 2.
Yes, Your Honor. No, the 10 to serve 2 is what he came off of.
Okay, what you felt had been agreed to was
Yes.
the 10 to serve 2.
All right.
But of course, it's not agreed to, so it's incomplete.
Yes.
And so prior to just now, Mr. Arnold, in talking with Ms. Wood, said, I would rather go non-negotiated, although knowing that your recommendation was going to be 10 serve 2.
Yes, Your Honor.
Understood. Thank you. Ms. Tucson, I heard about 2 prior convictions Mr. Arnold had. Do you have anything else besides that?
One, the first one from 2016 and one from 2018, that's the current probation revocation.
And
17 SC.
the 16 SC case is closed out?
That's correct.
Thank you. Ms. Wood?
Thank you, Judge. If it's okay, I'm going to sort of talk a little bit about both cases at this time, just to try to make it make sense. So Mr. Arnold has actually been in custody since early July 2021. And this case has been, the probation case, the 17 SC case, has been on the calendar a number of times. At first, we kept resetting because Mr. Arnold was intent on hiring. At first, it was Renee Rockwell, and then it was Randall Strozier. And so that's one of the reasons that it's kind of been, you know, floating through the rotation. And so Mr. Arnold decided in December that he did want to move forward with me as his attorney. We had a discussion back in December. It was his desire to move forward to an actual probation revocation hearing because he did not want to plead guilty to anything or resolve these cases. Mr. Arnold and I had a very lengthy discussion yesterday at Cobb County Jail, and that is when he decided that he felt it would be in his best interest to resolve the 2020 case as part of a global resolution for his Fulton County cases. There has been a bit of a back and forth between Mr. Arnold and I about what he would like the resolution to be. The 10-serve-2 I felt was a reasonable offer, and he has a desire to ask the court for something different, which is completely understandable. He is asking the court for the 10 years probation to serve 1 in custody with the 9 years to be the balance to be probated. And then he's asking for the credit that he has served. So he's been in Fulton County Jail since July the 9th of 2021, which is 197 days. Just a little bit of background. He is 28 years old. He's got 3 children, ages 4, 5, and 7. He's a high school graduate, and he was most recently gainfully employed with First Step Staffing Agency. I know that he did have a question for the court earlier about the resolution. He's shaking his head, so I think he may want to address the court at some point, but that is his ask, Judge.
Sure. Okay. Let me see if anything you said prompted questions. You are saying that based on your last discussion with Mr. Arnold, the defense request is 10-serve-1.
Yes, Judge, that is the most recent ask from our breakout session.
Got it. Okay. I think I follow all of that. Do you know, Ms. Wood, if anyone else in the car that was pulled over on May 15th of 2020 ended up being charged?
Judge, it's my understanding that Mr. Arnold was the only person arrested from that incident.
So not the driver, but the guy who said, my ID is in that bag, and in that bag allegedly is all this other stuff.
Yes, Judge.
Okay. Get back into the CP case. Mr. Arnold, tell me what you want to add. You've been listening as best you can. I know it's kind of noisy there. They've got a kind of makeshift setup because this is not where we normally have Fulton inmates. Is there anything you want to add to what Ms. Wood was saying?
Only thing that I wanted to add was when I was in the car, the gun wasn't mine, but how the officers went about it that day, they just went ahead and put the gun on me because the person went on up to the gun. And like they said, the driver's ID was in the bag. My ID was on me. That's all I like to add, Judge. You know? But I was just trying to see could you be lenient to look at the 10-do-1, please? Because I got kids. I got a whole life ahead of me. You know, people make mistakes. You know, I know it's up to you, and it's in your hands. So.
It is up to me, but I appreciate you sharing that. One thing you said before we got deep into the plea was that you had an interest in drug court. Tell me more about that. Why do you think drug court is something that would be helpful for you?
I think drug court would be more useful for me because I'm definitely I admit I got a problem. I admit I use drugs. I know the consequences with using drugs. My mom is a crack addict. You know, I've been on drugs before. Like people people in my family do drugs. Like, you know, my mom was a crackhead. You know, it's not my fault. Like, that's all I like to say. So I really feel like the court should be. I mean, it should be lenient to, you know, help me, you know, get drug court so I can get some help for myself. Therefore, I can get back out and help my family. Because I already been in jail 8 months.
What drug or drugs do you find that you struggle with the most?
Marijuana, crack cocaine, MDMA, pills.
So all sorts of stuff.
Yeah, I need help, but I've been clean for 8 months. I've been clean.
Well, good.
Been doing.
Well, partly because you've been in custody, I guess, but that's good. All right.
Trying to change my life.
Ms. Wood, I think I'm gonna treat this as an offered plea. Are you okay with that?
Yes, Judge, please.
Okay, we'll do that. It doesn't sound like Ms. Charles had an objection to that. In fact, she very nimbly shifted to that when Mr. Arnold expressed the concern that he did. All right, Mr. Arnold, couple things. One, need to make sure you understand that an offered plea, which is a best interest plea, what you're doing right now, is perfectly acceptable. Your version of events is different from what the state thinks that it would be able to prove if the case went to trial. But you are saying, you know what, even if it may have been the other guy's ID was in that bag on my stuff, Mr. Arnold, I just want to move forward. And I think it's in my best interest, meaning your best interest, to work the case out. Is that a fair statement?
Yes, Judge.
Okay. Now I'll treat your plea as an offered plea. I do find there's a factual basis in this case. If the jury believed what the officer said, they could find you guilty. I don't know that they would believe the officers, they might believe you, but I also understand you not wanting to risk that, because going to trial could result in something a whole lot worse for you. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to enter this plea, but you decided it's in your own best interest, which you told me. And a knowing plea means you've understood the things we talked about, and if you didn't, you asked, and you've done a good job of asking questions. At this point, do you have any other questions?
Oh, Your Honor.
Okay. I'm going to sentence you pursuant to the Probation Options Management Act. What that means, Mr. Arnold, is that when you are on probation, which you will be for a bit, if you have a technical violation, something small, you and probation will resolve that. But if it's more serious, you get arrested again, or maybe you test positive too many times, that'll come to me, and we'll work through what the sanction should be. All right, so what I'm going to do, Mr. Arnold, I'm assuming, Ms. Charles, that the 4 counts go in the order you described them. Count 1 is the cocaine, count 2 is MDMA, 3 is marijuana, and then the last one is the gun count.
Yes.
Okay, all right. So I'm going to sentence you, Mr. Arnold, on count 1 to 7 years to serve 2 years with the balance probated. Counts 2, 3, and 4 are all going to be the same, and they will all run concurrently, meaning at the same time with count 1. You're going to get credit for all the time you've been in. These are all parolable offenses, so you are eligible for parole, as far as I can tell, the moment you get into Department of Corrections custody. They'll do all that math and figure that out. I'm going to revoke. How much time remains? I never asked that question on the 17 SC case.
He has 5 years, 7 months, and 30 days remaining.
Okay. So in the case that actually brought you to me, Mr. Arnold, I am going to revoke 2 years. You'll get credit for the time you've already served, and that revocation will run concurrently with your sentence in this new case. I'll reinstate the balance, and the basis for the revocation, of course, is this arrest in May of 2020 and the resulting accusation. I did not ignore what you had to say. I was listening. I'm listening carefully. I did not ignore what Ms. Wood said. What I relied on most of all was the sentence she got last time. We were in front of Judge Downs in the 17 SC case. And in that case, you got a sentence of 10 years to serve 4 months. And those 4 months were reduced to time served. So it was a similar set of facts, at least the charges were about the same. I don't mean to suggest the facts were the same. The charges were similar. And we already did, let's get you out, get you some drug screens and this and that. And here we are a couple of years later, and you're rolling in a car with some guys who, if it's not you, someone else is doing some pretty heavy duty drug dealing with all those different things in the bag. That's not personal use quantity. So I think it's appropriate to bump it up a notch. Hopefully that will encourage you to keep doing what you've been doing the last few months, which is stay clean and working, whether it's with First Step Staffing or somewhere else. We'll handle it that way. So in 17 SC 153471, revoke the 2 years, reinstate the balance. And the main change I'm making from Ms. Charles's recommendation is I'm shrinking your probation a whole bunch. If you have decided that, dang, at age 27, 28, I'm done with this jail thing, I got 3 kids, I got people I care about, you're going to make those changes. That's going to be on you. I can't make you make those. I can sentence you to 10 years. I can sentence you to 1 year. You'll eventually reach that age where you're going to try to do things differently, and things will work out better for you. So that's how I'm going to work it. It will be a special condition of your probation that when you get out, you will submit to a drug and alcohol abuse evaluation. And if that expert says, hey, you know what, Mr. Arnold should get some treatment, any treatment that they recommend will be part of your probation. Otherwise, you'll be able to do what you need to do. I'm going to waive your probation reporting fee for the first 4 months after you get out, because you're going to need to get to work and provide for your family. But after those 4 months, you are a smart young man, you are physically capable, you'll be working again, you can pay that supervision fee as long as you stay on probation. If you do well on probation, they'll make it non-reporting as soon as they're comfortable doing that. So you've got an incentive to stay out of harm's way once you get back on probation. Ms. Charles, did you have any other conditions you wanted to have on the probation?
Hey,
All right, Ms. Wood, anything else on behalf of Mr. Arnold?
No, Judge, I think I missed the sentence for count 2, 3, and 4.
They're all the same. It's 7 to do 2, balance prorated on all 4 counts. They're running concurrently with each other.
Perfect. Thank you, Judge. I have nothing further.
All right, Mr. Arnold, any questions?
You said it was 7 due 2.
That's what I said.
It's gonna be the 2 whole years, or am I gonna get my 8 months? My 7 months I've been served, so it's gonna be like 17 months.
Oh yeah, no, you get all the credit for the time you've already served, and these are all parole eligible offenses. So yes, sir, you get credit for every day you've been in, and they'll make sure that gets logged, okay?
Yep, so it's gonna start at, so I'll probably get out in like 15, 16 months, 16, 17 months.
Yeah, maximum, that's what would be left. All right, thank you, everyone. Thank you, Cobb, for keeping Mr. Arnold available for so long.
Thank you, Judge.
Is there a credit date? Is there an actual date that we can put on the revocation order?
Ms.
7/9/21.
Thank you.
Great, thank you. Ms. Patel, I saw you back. Did you get a chance to talk with Mr. Coleman?
Yes, Your Honor, I did. I do have a few questions for Your Honor since I just got this case.
Okay, let me get Mr. Coleman back on and unmute him. All right, Mr. Coleman, can you hear us?
Yes, I can hear you.
Great. Ms. Patel.
Your Honor, Mr. Coleman brought to my attention that the discovery deadline that was in the case management order has passed. I don't know if Your Honor intended to issue a new case management order or if the dates in that order would still stand.
Well, this case has been a little topsy-turvy because of the friction between Mr. Coleman and Mr. Ford, and in particular, whoever this young lady is on the outside who's doing things on behalf of Mr. Coleman, who's the one who keeps calling my staff and being impolite to them. So I certainly want to give Ms. Charles a chance to get discovery to you, because whatever was gotten, I'm assuming this is Ms. Charles's case, I don't know. It's the one on our supplemental calendar, Mr. Coleman. But it may be a specialized unit if the.
That's what I'll figure out.
Either way, so Ms. Patel, you need to get discovery. I'm not interested right now in imposing any sanctions on the state.
Sure.
Well, I've gotten things to Mr. Ford, and then that relationship soured real quickly. So why don't we figure out who's handling it for the state? If the alleged victim is the stranger, then it's Ms. Charles's case. If it's not, it's specialized. But either way, we'll get you that discovery, and you will certainly have additional time, Ms. Patel, to file motions if that deadline is already run.
Yes, and it will be Ms. Charles. My understanding is that is a stranger. The other question I had for Your Honor is that I understand that Mr. Ford filed a bond motion. Would Your Honor want me to file another one, or can we be heard on the original motion, not today, but at a future date?
You do not need to file a new one. I don't remember all the drama. I think maybe there was I'm familiar with there having been a bond motion and then it not being heard. So no, you just need to work with Ms. Nelson to figure out a good date to get Mr. Coleman back here virtually or in person for the bond to be heard with enough notice to the state that they can reach out to the alleged victim if that's what they choose to do. So the usual plan, you don't need to file something new.
And then lastly, Your Honor, my client was under the impression that something of substance would be happening today on the case. I explained that this was simply to figure out who would be representing him. With that being said, I did tell him that I would at least ask whether there was an offer that Ms. Charles may possibly have that would potentially resolve this case today. My client has indicated he would, if there was a way to resolve it today, he was interested in that. I certainly don't want to put Ms. Charles on the spot or to have her make an offer that might be unusually high if she's missing some information. But I did tell Mr. Coleman that I would at least ask in the event this case could be wrapped up today.
Got it. I won't require Ms. Charles to say that in front of me, but Ms. Charles could reach out to you, Ms. Patel. We can have Mr. Coleman sit tight for a minute. Why don't we freeze the Coleman matter for a brief second, because I want to hear quickly from Mr. Fortis what we might be doing today on Ms. James. And then we're going to need to pause because it's lunchtime anyway. So let me hear, Mr. Fortis, are you there?
Yes, Judge, I'm here. I've been waiting. I need to speak to Miss Charles, hopefully to get some sort of offer. I'm hoping that whatever agreement we have, I'm hopeful that it will resolve the case and she'll be released, but I need to speak with her first.
Okay, well, why don't we do this? I need us to break now. It's high noon.
Judge, I can't be back this afternoon. I've got to take my daughter to a school meeting and it's going to start at 1:30. And I don't know how long it's going to go.
So what you can do, though, is sit tight and talk with Ms. Charles. So you guys can have a conversation. We can figure out what's next for Ms. James.
Yes.
Ms. Patel could do the same with Ms. Charles. And if either one of these is something that we could sort out today, we've got all afternoon. There's a hearing I need to have in another case, criminal, but we'll be, I think we don't know. But we have this Zoom session for a while. We're down to just 2 defendants. I want to at least get closure for them today as, hey, it's workoutable, but we'll do it next week. Or this is the kind of thing that is going to take a little bit longer. We need to have an evidentiary hearing from James. So that's where we are. I'll ask Ms. Charles to connect with both Ms. Patel and Mr. Fortis, and then just let Ms. Nelson know what we're going to do, and she can let Lieutenant Dooley know, hey, Mr. Bowen can go, or Ms. James can go. Okay.
All right, can I get Miss Charles's number, or do I need to give it to her because I have no way of reaching her?
Yeah, if you put in the chat your phone number, she'll be able to see that and she can give you a call.
I tried to do that. I didn't see, unless I overlooked it. I just didn't see her name in the chat.
She's not what just she's not in Zoom. She didn't need to be because she's sitting at a table here, but she's gonna log into Zoom now. She'll be there. You can get her your number. And Mr. Coleman, Ms. Charles will talk to Ms. Patel, and the two of them can figure out if there's something that could be done substantively with your case. It's on the calendar simply to get you a lawyer. You need a lawyer for your case to move along. I never say no to progress if there's a way to sort it out, but that may not be in the cards for today. Ms. Patel will talk with Ms. Charles, and then they'll let you know what their conversation is like, okay?
And so, Your Honor, if Miss Charles and I are able to reach a consent, is that something that can just be given to the court, or does she and I have to go before the court if we're able to resolve it today, which may result in her release? I don't want her, and maybe I'm being rather ambitious, but I don't want her to be staying over the weekend because of my inability to be back on a call this afternoon.
So you and Ms. Charles should see what you can sort out, and I can't answer the hypothetical. It just will depend what you all sort out, and we'll go from there. I will say that what Ms. James got, what the petition was issued for is old and in a remote jurisdiction. Some allegations out of Oklahoma from a long time ago. So it does seem like the kind of thing that might be worked out, and I'm open to that. But we'll have to see what the two of you discuss. Okay.
And Judge, one last thing: if Miss Charles could just read off her number, because I don't see her on the chat platform, and that way I'll just call her.
Yeah, she's not logged in yet. All right. I will be back around 1, and we'll see if we're doing anything more with either Coleman or with Ms. James. Otherwise, at 1:30 we've got to hear. All right.
Judge, may I be excused?
Yes, ma'am. Thank you for all your help today.
Thank you. Have a great weekend.
You too. Well, I'll get back as soon as I can, and if we're doing something here, it could be, you don't need to be here before 1. Does that work? But definitely 1:30, we've got a hearing on one of these cases. So we'll call it 1. Thanks.
That was on Miss James. We still have Mr. Green.
So we're able to resolve the issue with the attorney that has to go to the dollars.
Are you guys gonna do the revocation now, Mr. Miss James?
I'm gonna find out.
Okay.
I'm putting in there.
Right, we'll hold. Wait.
I think
Decide something that may resolve it.
I'm just checking out.
Release.
I guess I don't need to take this stuff with me.
Yes, so are they going to do the revocation hearing on this person? He's there, or they're talking? They're going to do a revocation.
I saw missing.
Such a- Well, I mean, they still have to have the revocation. The attorney said, he was saying, I have to have my daughter at school at 1:15 or 1:30. And he cannot come back at 1. So he said, yeah, but the sheriff doesn't need to come back in because they're not going to have anyone do it for other than just the judge. I guess, I don't know, whatever you want to do is fine. Just make sure you get the revocation hearing.
Today's assembly.
It's a lot of the revocation. Is this Miss Jones? Okay, so she's the only one, she has the new charges in Oklahoma. And then, but I guess if y'all want to do this, that's fine, I can do the revocation for some of the time. But you know, if they give her a bond here, I don't know if there's a, before they release her, they may see the hold in Oklahoma. On TC, on NCIC. That's cool. I mean, I'm fine with it. You're in 1 month and 9 days. She hasn't been that. I did not see that. I was not here a credit day. Whatever you wish to do, if the judge will accept it, either bond or the charges in Oklahoma, we don't know what's going to happen. If you want to revoke the commute, I'm cool with that. That takes her off probation. You know what I'm saying? But of course, she left the state without permission and what they do with that. So she was ordered to $400 so 6 years old. She completed. She has a balance of 398. So she didn't do her community service either on the original sentence. If you want to do a bond, that's fine. If they take her away to that other place, the warrant will still remain in place, I imagine. They will take her to Oklahoma if they see that there's a retainer or something. They will ask her if she will waive extradition back to Oklahoma. But I don't know, do you have to waive extradition on a new case? So if she waives it, she would then go to Oklahoma. And then she'd have to appear back here on her probation bond, whatever Oklahoma is resolved. And I imagine if she has a warrant, what she does have, the warrant will remain in place, I imagine, unless you cancel the warrant, and then you would have to issue another warrant. Okay, I mean, she does need to have some, there needs to be some recourse for, first of all, for getting rid of that. Secondly, for leaving the state without permission.
He doesn't have any sense of, I guess we just revoke her.
You're in 6 months. If you want to remove a portion of it and then suspend the balance.
Right, and I guess after, but it still keeps her probation here.
Well, if you revoke some time and suspend it, then she would serve whatever time here in either staying in Fulton County jail, probably in Fulton County jail. I don't know how that all works. Then she would be released to go to Oklahoma.
It doesn't want that, come out.
Okay, we'll just do the consent law. We'll see what happens. That'll be fine. Then she could go to Oklahoma.
Right.
And you know, the charges there may be dismissed.
And then,
If
if I continue probation.
Uh-huh.
Can you just email it to me? And let me know what you guys do.
I will come back.
Yeah, okay, okay.
Well, okay, so we would back at 1, you think?
Yeah.
Okay, all right, excellent. Okay.
I don't need any of this, right?
Not necessarily, are you still comfortable leaving it? Yeah, okay. There's 1:17, there's no time to actually do anything, so. I don't know how they do stuff in here.
You want me to put anything up to?
I'm going to just take this with me. Go ahead and stick all mine in.
Well, you take yours and I'm gonna take mine.
It still must be up on the wall, so it won't say this stuff. But you, I mean, you can leave it if you want, see what happens. That's good, I'll be back at 1.
We'll try and find, but see if the place is open, I hate that I didn't bring them.
We live in Mara.
Oh, yeah. I think I had that with the camera. I don't even think I brought that. You can have it over.
Right on the line. You said you were leaving at some point today. Was there a time? Did you say you were leaving?
No, I was just saying we could do that calendar on Monday, that I already researched.
Okay.
Tuesday, if, you know, this afternoon goes too late, I wanted to make sure I left by 3,
Okay.
3:30,
Yeah.
4 o'clock at the latest.
Maybe part of the time, yeah. Okay, I'm not wrong.
Okay,
not gonna come back with a probation. And we've got.
Oh, and yeah, I feel, I should have spoken his shoes first.
Yes, you should have. You should have, because you saw me that.
But we'll discuss it around.
Yeah, we did look at
Yeah.
I'll give you this. I'm sure. It's still a lot of it.
Should be, well,
I'm not
yeah, I won't do it. I would, just think, actually, you know, you got last you gotta go to this property, right?
Are you, Cassie Wallace?
But you can't.
Yeah, I didn't know. I didn't know. 2008.
Long time.
Yeah,
Long time.
yeah. Yeah.
Maybe.
Don't do that. When I first got here, it was so bad. How are we not coming? Remember the little bit? Bring it on. Yeah, right.
You understand, you understand where it's at?
Absolutely.
You gotta get us.
And you should have first. That's how it's going. I'm really good position.
Did y'all do the consent line?
No, no. Hey, I was doing it. So we're gonna do the verification very quickly. So I hope this is the new charge, which was revoked 6 of the charge.
Okay.
And with additional conditions, plus, such as revoked 12 months, revoked community transfer, plus present. However, the charge here, January, no.
Okay. Okay.
Because I think she has additional.
You still have the community service on the, you know, on the 18SC unless the judge leaves that condition.
Okay, right now.
Mhm.
On the 19th, she was, Judge Crum had a parenting class. I guess I was
Don't know. See if I see something.
how much do you know in college?
400.
20,100.
No, she did that. She did 2 hours.
Oh, she's like 20.
Well, not to do the community service for sure. She's not trying very hard to stay out of trouble either. Bless her heart. Not so hard.
No.
Yeah, that is a bit of a hassle. You know, the community service, they want you to do like 16 hours a month, maybe. And, you know, you can actually get by with less than that without getting into any serious, you know, complications. But of course, there was that COVID thing that they had going on for a while, and that interfered with a lot of things. When was that? Was that in 2019? I don't even know when it was.
Probably looked like it showed up in May.
Okay.
Because that was a lot, years, 20 years.
So this one, she's on for the 18, is it, it's the first offender?
Yes. Because the department said, look, you got second chance criteria, so can I help you?
Well, you know, technically, when she goes to, we go to process the first offender, just, closure, it won't be closed because she has, if that's a new, if the offense date occurred after she was placed on probation, she will not get her first offender. It will be, it will not be signed, it can't be closed. That's required. So I'm sure she needs to report back to, whenever she resolves those issues with Oklahoma. If they do pick her up, or if they see that hole in the jail.
I see where they have this instinct of research back.
Yes.
And that would be verified.
I don't know what is going on in Oklahoma. Maybe a new charge. They may, I'm sure they'll probably try to take her back or something. These things. That'd be a listing issue that she could do with on her own. Sounds fine. Huh? Sure. She has one here, 1 month. Could you start writing up anything about the revocation hearing for Mr. Arnold? Did you like?
What was the one you said?
Yeah, I know, but since we're here and we have a little break, we should probably do that. And then the judge can sign it. Okay, all right, I'm not staying all day, of course, if you are not either. Getting out of here since we're over shortly. So,
We only have 2 more people. Okay, let's. How about it?
We'll get back to the office first. Now, the one that was for Marcus Brown, or whatever his name was, remember that one? That needs to go ahead and be, it needs to be, I need to have that, scan it and keep that. Then we also need to get both of the sets of sheets on them. We don't have them. I think we have both of them now. I think we should email copies of one. We need to have both copies of those, and the packet needs to be put together and sent out to the CEO. Copy going to the loop is the alternative case processing.
So we're still gonna put it in ourselves.
Still going to put them in RSAT, talk to the judge. When were we here last? Are we here every day?
It seems like it.
When we were last here, the judge mentioned something about that. The whole thing said they were trying to resolve it. So we'll go ahead and go with all of them now. Let them figure out when they're looking.
I'm here for the brand.
Yeah, I did start.
What you said before. Okay.
Let's start. You know, they did give us the credit for time served, 7/9/21. Credit for time served.
I just want to make sure, I want to show you, I really know that. Yeah, let's listen. So I'm gonna write my own. Which is generally like this. Okay, good.
Well, all I did was put the date in there.
It's okay, keep writing, and then I'll copy it onto my book.
Yeah. Yeah. Stay the second here, we'll scale this one. States that you are here. Yeah. That's right there.
Okay, so. Let's see if I can. So. So. As well.
Probably good. Okay, all right, pull up.
It's not permanent case, that's a temporary case. New charges.
Okay. Ooh. I got it. That's really good for the.
Charges.
What's going on today? There's.
What do you guys, the 28th.
There's not a number.
So we're not.
It's not, I think it's 20. I don't have the number up.
So Jim, that's not very good.
The OTN number, I don't know what it is. I don't know if that's the original OTN number of that the case was sentenced under, or if it's the OTN number of the probation revocation. I think it's what it is. See what I'm talking about? You have to have the offender tracking number here.
Wait, where'd you get that?
It's going to pull up the TCIC, criminal history, arrest, correction.
Criminal history, arrest.
It should be very good. Probation violation. See, cycle number 7. 21. Offender tracking.
Is it at the bottom?
741. Look at the cycle number 7.
Where do you come from?
It's down to the last, it's the front end of the last actual arrest.
Your. Oh, okay. Huh? Upward. Okay. So, I was curious, where were you? Were you prosecutor?
It's just, if you go to the GCIC, it's just like you should arrest up. The GCIC. Scroll up because those are the agencies.
Yeah. Okay. Oh. Secret
So they're at 45,
005. I did that since 005.
yeah, but those are the charges.
Yeah, okay. All right, so you needed Jeremy.
The 004, the 005, the 6.
Yeah.
What is it? 4254, 1674. Right? You're gonna put in,
Yeah, it's a large office. Keep the number going. Yeah. Yeah, that's all. What else? Sorry, really.
so social charges, 23, 191, then down here is revoked. Rather than some of our attention.
It's him, it's him, I'm looking at his, petition.
Social charges here, as a order of the judge, fast, it's revoked 2 years, right?
Yes.
Not the balance. It's 2 years. 3 days. None of this other applies to. It's not reduced to time served, it's not 2 years. One some condition. Go down to the next section, upon the service of time, the defendant shall be reinstated under probation. So I'm sure you wrote down revoked 2 years, reinstate, reinstate, right? No, we're on the revocation. Revocation, revoked 2 years, reinstate the balance. It's not, that's commuted to time, so it's spread 4 times. CF. So, you know.
Is it there different?
Yes, absolutely. Commuted to time serves, basically doesn't have to serve for 2 years. Credit for time served means it serves for 2 years. From credit at 7/9/2002. All right, so.
Okay, so defender said he likes it.
This is based up there, 20 CP. 191,005, which is one where they sentenced him 5 years served, 2 years, 7 years served, 2 years, and $1 per day. So that's the same case as referenced up there. And then you need to write, well, that's it, and that's it. So, docket number, booking number, FRC number, and the offender tracking number from the rap sheet. He has violated the terms of probation, subsequent new charges, 20 CP 1158. Vote 2 years, 0 months, 0 days. On the service of 2 years, you should be reinstated on probation under the conditions of the original probation. And simplest is to write currently X. To write currently with CP 28 down here at the bottom. Credit for time served from 7/9 to I wish that I knew the CP case really well.
Oh, it doesn't say CP. It says 20C1.
So C1?
No, it says 20 and then C19.
See, there's nothing out one of the initials is probably CP. Oh, sorry, sorry. I'm writing out the revocation order. Is that the correct? You took continue on that. It's not indicted yet. I think it's a CP number. Okay, cool. Thank you so much. It's CP. It's what the
One CP 191 ready. Okay.
So the order is completed. actually can be given to the judge for the sign. Okay. You just have to scan it. Both getting that back to you as well as to do. And because that all would bypass the judge, it needs to, I need to e-file that, so I need to get a copy of Marcus Brown to the office. So I can scan it and e-file that document. So it is. Marcus Brown. It's probably already, so it's the.
I can answer that.
Okay, so I need the application board to the side.
So you must have get something. I remember that.
So if we don't have one, we have to prepare one. So, right, so I mean, we need to do this today, finish this, and don't try to remember to do it in later time. So or we or I have already lost that one that is already assigned and waiting. There are going to be so many things coming at you so quickly that you will not remember what that past. It's best to fall through patient as many things as possible. So they don't have to be revisited.
Yeah. Just need one more thing about the. Oh, yeah, and the baby, yeah. Yeah, really.
Yeah.
Thankfully so.
We voted on it. We just doesn't cost a little bit to hold it because we thought the judges are not this judge. It was not e-filed. It's not uploaded. Yeah, I think it's not. We're still waiting on those other two cases. We have those other two cases. We have to do the application for.
Yeah.
And the two cases. When compare the packet. At this point, we're gonna have to hold for the revocation order. Another one has to be sent to the judge to sign because it's been lost in this slide. So we were here, and I specifically had to do it, yeah. So you can sign it before you left the bench. Because I was afraid that it would get mislaid in some sort of way. We waited on.
That's an example of scanning this.
I'm good. I mean, we're gonna be doing it, so yeah, whatever works for you. I'm not gonna do that. I'll tell you what needs to be done is something you would we have to do a revocation order on, just did one on that person. We scan that and send it to Deidre and Mr. Arnold. And you can also do one for Mr. Marcus Brown. And send that to Deidre. not a credit day for the month. It has to be a credit for time served. Order all items on this brown all the way to. This is the Marcus Brown. What? Now, the revocation orders, when you do them, are supposed to be in the name that they were indicted on. So we're doing the revocation order of Marcus Brown. We want to look and see what name he was indicted as. That is on the sentence sheet. So we pull Marcus Brown and look for the sentence sheet. This is something that was supposed to have been done. I mean, we're trying to wrap up to it, so. This one- Okay, be here now. This was the plea we took on the Marcus Brown. We have to prepare a revocation order for this. We have to have both of these documents, which are new sentences. Both the revocation order here, the party data sheet for these two new cases, and the indictments for these two new cases.
Which we don't know what that's good. Because remember, we have prepared the whole thing for our right?
Okay.
So that also be there, except for the last, that was the last thing. Last, for the she
I think so. I mean, that was 300 emails.
Well, that's on order. Would you mind right now pressing the got it button? What? Deputy Palmer should do that. I think it's a touch screen. You got it. You can see that screen. Okay. Lieutenant Dooley, can you hear me? Okay. feel bad if she was holding Cobb. We finished with Cobb. But we should still, Charles is still here. Great. So let's close the loop on this morning's calendar. I don't see Fortis on, but we still have South Annex. Did you and we're good? Okay. You hear me? Lieutenant Julie, we're all done with Cobb. You finished with Cobb at noon.
Okay, thank you.
Sure. We just have the 2 folks left that we're going to try to wrap up right now.
That's the Union City and the guy in One North.
Yeah, we
Okay.
got Ms. Coleman and Ms. James. We just, the lawyers needed to confer, so I gave them a break. Let's start with Ms. James. Did you get a chance to speak with Mr. Fortis?
Yes, Your Honor, I did.
Okay, and
Reached
what,
agreement. And so in light of the fact that the terms in which she's being currently revoked happened on January 16, 2019, just prior to the previous revocation she had on May 17, 2019, where she was revoked by 6 months. We agreed to revoke 3 months, continue on probation, and commute to time served.
so commute to 3 months
Yes,
to time
ma'am.
served?
And
Okay.
continue probation. She has also outstanding additional special commission she has to get completed, which is community service for 400 hours of parenting practice.
It's a lot of community service. All right, well, let's get Ms. James on. Let's see if I can- South Annex. Can you get Ms. James on for us?
She's right here, Your Honor.
Fantastic. You guys have been real patient. I appreciate it. Let me get this guy off the screen, and here we go. All right. Ms. James, your patience has been worth it. We had to track your lawyer down, whose last name is Fortis. He is Scott. That's his first name, Mr. Fortis. And he spoke with Ms. Charles, the prosecutor, and it sounds like they've agreed to recommend that 3 months of your probation get revoked, but that be reduced to the time that you have already served. Does that make sense to you? Understand what I'm saying?
Yes, I believe so.
Do you live in Georgia or do you live in Oklahoma?
No, sir, I live in Georgia.
Okay, you were just in Oklahoma at some point a few years ago?
Yes, I was driving from California and I got pulled over with a friend of mine. And I have reached out to them to try to, resolve the issue. I'm just waiting on them to let me know how they want to go about the situation.
Okay. You are still on probation here in Georgia, in particular in Fulton County. It sounds like there's some important conditions of probation that you need to get working on. Did you know you had a bunch of community service to do?
Yes, sir. And actually, I did 200 hours of community service, but they told me I did it with Red Cross. And once I turned my paperwork in, the supervisor told me that they don't work with Red Cross anymore. So she told me I had to start coming down to the actual, like the probation office and do my community service that way. So that was just a misunderstanding. I was under the impression that I could go to the Red Cross because that was what I was told, in the beginning of my probation sentence.
Sure, and it may well be that in the past you could have done that. Sounds like that's changed a little bit. We've got some probation folks here. I'm gonna make sure you get credit for that. I'm looking at the sentence that Judge Downs gave you back in September of 2018. Okay, you're supposed to do 400 hours of community service, and you're saying you provided documentation for about 200 of them?
Yes, sir, and I do still have that documentation at home somewhere. I just gotta find it.
Okay, and were you told that you can get credit for those hours, but you cannot do any more work there, or that you were starting back at zero?
Basically, she told me that because I can't work with Red Cross, I wouldn't be able to use those hours, but she had started giving me, I believe it was like 50 hours, just to get it moving on from when I was in her presence. She had went on ahead and signed off, but she told me that I was starting from there, which is a headache, but.
Okay, well, let me ask, Ms. Tucson, do you have any information in Scribe or whatever the system would be as to any credit Ms. James has received for community service hours?
It's not showing that on here, that's why they said there was a large balance left.
Sure,
over.
well, if it says no
Right.
credit, that would mean
Right.
400 hours left.
Correct.
So, what I'm gonna do, is, I have to sign an order that deals with the revocation. Again, the basis for the revocation in this case was that you got arrested, in January of 2019 in Oklahoma for whatever was going on.
I'm sorry, Joe. I didn't mean to interrupt you. This is Scott. Is this my case?
Oh, yeah, you're back. I didn't know you were here.
Yes.
Great. You had said 1:30, you turned into a pumpkin and it's 1:36. We're talking about your case.
Well, I worked with the prosecutor in the case. I thought we had an agreement of what we were going to do with the case, which was revoke some time, commute it to time served, and then reinstate. That's my understanding.
Yep. So did you just join the call again or were you here the whole time?
No, I joined the call about a minute ago.
Okay, so you missed what Ms. Charles said, which is that you and she agreed revoke 3 months, reduce the time served, reinstate the balance. And then I had just been chatting with Ms. James about the community service because Judge Downs had imposed a fairly meaningful community service burden, 400 hours. And I wanted to understand why Ms. James had not done any yet. So actually, Judge, I'd done a whole bunch, but I did it with the Red Cross, which used to be okay, but may not be okay anymore. And so we were just working through that, but I had accepted. Ms. Charles shared with me what you and she had negotiated. I thought you were gone and you had authorized Ms. Charles to let us know what was going on.
I just delayed everything a little bit. So I appreciate Ms. Charles doing that. That is what we discussed. But I just wanted to, they ended up calling me back. So I'm parked outside. So at the appropriate time, I can just go in. So I appreciate that, Judge and Ms. Charles.
Well, we'll wrap it up. So what I am doing in 18 SC 159425 is revoking 3 months because of the arrest in Oklahoma, reinstating the balance. How much time remains on probation for Ms. James?
1 year, 1 month, and 9 days.
And if I revoke 3 months, does that mean then we're down to less than a year, or that was minus the 3 months revoked?
That was not mine.
Okay, then I'm going, how long have you been in, Ms. James?
Since the beginning of December.
So a month and some change?
Yes, sir.
Okay.
December 14th, Judge.
Is home for you on Marywood Drive in Fairburn, or you live somewhere else now?
Yes, sir. That's my address.
Okay. All right. Well, I want to leave a little more time on probation than that would do. So what I'm going to do is revoke 1 month, but I'll give you credit for time served. You've already done 1 month. I'll revoke 1 month and 9 days. So it's just smoother. You have 1 year remaining on probation. So I'm revoking 1 month and 9 days. And then we're reinstating the balance. You've got a year left. I'm going to request that the Department of Community Supervision give you hour for hour credit for the time that you can document that you worked at Red Cross. So you're going to want to reconnect with probation. They'll have an order from me that says you ought to get hour for hour credit for all your Red Cross time. If you can document it, and you said you still got the paperwork, which is
yes, sir,
good,
I do.
Good for you. So bring that in and meet with your officer. That'll still leave a pretty healthy balance. You've got a year in which to do it, so you're going to want to get rolling on that.
Yes, sir.
The other conditions of probation were stay away from someone, no guns or fighting. Hopefully you take care of that. And that was it. Were you working before you got arrested?
I was, and hopefully I can go back to my job after sitting for all this time.
Yeah, I hope so too. What was that job?
I was a patient coordinator at Gold's Plastic Surgery.
Okay. Well, you ought to get out this weekend. Might not be today because paperwork doesn't move that quickly, but if you are still in on Monday, you call Mr. Fortis and he will call my office and we will figure out how to get you out, okay?
Yes, sir. Thank you so much.
Before you go, do you need any information, Ms. Tucson, or do you need to give Ms. James any information?
I just, sent Mr. Fortes, a message about him giving me his number, so I'll be in contact with him. And I'll have recording instructions and everything to that nature.
Fantastic. So Ms. James, Mr. Fortes is gonna have a quick conversation today with probation. They're here in court, but he's not, they'll talk on the phone, and then Mr. Fortes, that's Scott, he will let you know when you need to report to probation. It'll be the usual place where you've gone before on Memorial Drive, but you'll want to bring all your paperwork with you when you come, okay?
Okay, perfect. Thank you so much.
All right, Mr. Fortes, thanks for bearing with us.
Judge, no problem. You know how 14-year-olds are in trouble all the time.
All right, hold on a sec before you go see the principal. Yes, ma'am.
In the 19 FC 167869 case.
Oh, this case I didn't know about. All right.
So on June 26th, Judge Farmer revoked 6 months in a case where she had been charged with aggravated assault and was reduced by state custody and infection. And Judge Farmer requested she complete parenting classes. I was wondering if you were going to put that as part of the continuing condition.
Sure, we could do that. Different case, but I'm happy to do that. So I'll add as a special condition, Ms. James, of your probation, that you complete a parenting class, okay?
Okay. Will they give me the information for that, or?
You'll get that through probation. They'll want to talk to you about these community service hours, and then they can help connect you with the provider of the parenting class.
Okay.
Do you have kids?
Yes, I have 3.
Okay, then it makes sense. All right, then we'll get you. How old are your kids?
I have a 2-year-old, 6-year-old, and a 7-year-old.
Okay, well, it's a full household. Do they live at that address in Fairburn?
Yes, sir, they do.
Who's taking care of them right now?
My mom.
I know someone who really wants to get you out.
Oh, yeah, Judge. I can assure you that.
All right, Mr. Fortes, will you get your contact information? Are you able to see the chat, or on your phone, does that not show up?
No, it showed up. I sent my phone number and my email. Do they need anything else?
No, that's perfect. She got it. She nodded, Ms. Tucson nodded her head. So we are good. Thank you, Union City, for staying on this Zoom call. Ms. James is free to go. You guys have a great weekend down there.
You too. Bye-bye.
And Judge,
Bye-bye.
one before you go, I know you revoked 1 month and 9 days, but will you specify since 12/14/22 in the order, just so there's no confusion?
Yes, it'll say 21, but yes, it'll say 12, 14,
21. Sorry. All right, great. Thank you, Judge. Thank you for everything. It's good to see you as always.
All right, same. Bye-bye.
All right, bye-bye. Thank you, Ms. Charles.
You're welcome.
Judge, that time was revoked. Was credit for time served since the 12/14?
Yes, sir.
Okay.
So she's overserved based on what I wrote.
Okay.
I get that. I understood that. Let me get Mr. Coleman powered back on. He's still here, and we can probably get to this. All right, Ms. Patel, how are you?
I'm good, Your Honor.
So we've got Mr. Coleman right there on the screen, and he is unmuted. Tell me what you and Ms. Charles discussed, or whatever you want to share.
Your Honor, we're not going to be able to resolve this case. Ms. Charles was correct earlier. It may be that Siri Patel is going to handle this case, because while it was a stranger on stranger incident, one of the individuals is under the age of 18. And so Ms. Charles simply just does not have enough information available to her to extend an offer today.
Okay. Well, I'm sure the DA's office will get to the bottom of that promptly, because that's not Mr. Coleman's problem. And they need to get to you, Ms. Patel, discovery ASAP, so that you and Mr. Coleman can start having a meaningful discussion about whatever the right next step would be.
Thank you.
All right, so Mr. Coleman, Ms. Patel will be in touch with you soon. She needs to get discovery. She needs to find out who her counterpart is on the case, and we will take it from there, all right?
Yes, sir.
All right, appreciate your patience.
Thank you.
All right, thank you, Ms. Patel, for jumping in this one.
Thank you, Your Honor, and may I be excused?
Yes, you both may.
Thank you.
Thank you.
Thank you, Ms. Charles. And with that, Lieutenant Dooley, we have completed our Zoom booth calendar. I appreciate all the support we provided, and sorry we had that little hiatus in there. All right, let us pivot to Mr. Drain. I think I see both Mr. Robinson and Mr. Drain's names on the screen. Mr. Robinson, you there?
I am, Your Honor, trying to get you maximized on my screen. Here we go.
Maximize me, but I'm there. I see you. I see Mr.
Right.
Drain. How you doing, Mr. Drain?
How you doing, Your Honor?
Are you coming at us from Illinois or Indiana, wherever it is you are?
I am here in Georgia with Mr. Robinson in the next room.
Okay. Is he in your office, Mr. Robinson?
Yes, Your Honor.
Okay, got it. Mr. White now just stood up, so we need to work through something. I'm just getting all the jail things. One second. Yeah. All right. So it was my understanding that we are here to work through the 413 motion notice that you served, Mr. Whitenauer. Were there other matters you wanted to cover in the Drain case?
Yes.
Okay.
Your Honor, I did file an amended notice motion on the matter of 413 and 404B. I filed and served and emailed a first copy to defense counsel to consider, in addition to the rape under 413, to consider an aggravated assault under 404B, as well as a strangulation in the second degree under 404B. Separately, Your Honor, it was my recollection, and please correct me if my recollection is wrong, that Your Honor would keep open its consideration of the state's motion to revoke bond, and that you had directed Mr. Drain to appear in person for all future. If Your Honor has a different recollection, then so be it. But that was my understanding of today's purpose, and then also your direction at that time.
Okay. Couple things, and then I'll hear from Mr. Robinson at this sort of high-level procedural. You filed the revised 413-404B when? Like yesterday, or I should be able to find it in the document?
Yeah, it should be on Odyssey, Judge.
So there is a January 6th filing. Would that be it? I mean, look, it doesn't say revised year. Something served on January 6th, admit notice of state's intent, 413. No, that's not it.
That would have been after that, Judge.
Okay. The clerk's office is backlogged. So if you, it may be that you all can e-file stuff that a judge files, goes in right away. But litigants, lawyers e-filing things, it's about a week behind.
Oh.
So if you filed it last Thursday, it might still be in the queue. I'm not seeing it. I see voir dire.
Well, you see what here, then it should be before that, because we filed the amended notice before voir dire was filed, which was this morning or yesterday afternoon.
Okay.
State's voir dire.
I'm looking. I don't have it, but you got a copy. More importantly, Mr. Robinson, have you received the amended or revised 413-404.
I have, Your Honor.
Great. That you're the important one that's between the two of us. Do you have a copy that I can look at, Mr. White now?
Yes, Judge.
I'm just not seeing it in the document.
Yes, Judge.
Thanks. Sorry about that. Okay. Second, as to Mr. Drain's whereabouts, my recollection, I'm not saying it's definitive, is that I needed Mr. Drain to be in Georgia, but I wasn't going to require him to be in court if Mr. Robinson was going to be remote. They could be in the same place, but it needed to be in the metro Atlanta area. So it's either you're with Mr. Robinson in his office, they may choose to be in different rooms, or here in AD, but not appearing from Indiana or Illinois.
My recollection is incorrect, and I understand.
Okay. It's a change as we get closer to trial. You can't appear remotely for trial. I don't think he wants to either, but for today, I'm okay with the setup that we've got. And then finally, as to bond, I do recall saying what I felt was appropriate status quo based on what you had shared. But depending on what more we learned here, if there was a warrant flowing out of the cab, because those were some of the things we discussed, I would revisit that whole question to make sure that we had Mr. Drain, but I thought was the right place as we approach trial. So if you've got an update on what's coming out of the cab, I'm happy to hear that. If what you want to cover is what's in your revised notice. I'm going to call it 404B for shorthand, your revised 404B notice. Then at the close of that, we could talk about bond. Does that work for you?
Yes, sir.
Okay. Mr. Robinson, so I think what we'll cover today is the 404B notice and the steps that the state needs to take to move forward with that. Was there anything else you wanted to cover while we have everyone together?
No, Your Honor.
Okay. Then why don't we get started? I'm a little behind in that there were a couple things added, but as I see, it's 3 transactions that the state is attempting to introduce as what call other acts evidence now, as opposed to similar transactions, because they don't need to be similar. One of the 2 strikes me as falling right in the heartland of 413, which I believe removes one of the 3 prongs of the test that the state needs to meet, and that would be proper purpose. I don't know enough about the first alleged transaction, the strangulation, whether that would fall into a 413 or not. I'll let you address that. And transaction 3, even though the alleged victim is the same as the rape allegation, I don't think aggravated assault, especially if it's not part of the rape, would fall under 413. It would be classic 404B. Mr. Whitenauer, do you have a different perspective as to which statute you'd be moving under and thus which tests I ought to apply in determining admissibility?
Your Honor, as guessed correctly, yes, the rape, we would be asking you to consider that for admission under 413, the strangulation and the aggravated assault under 404B.
Okay. Ms. Rivers, I forgot to check with you. Are you able to hear? Mr. Robinson is loud and clear to me. I think you're okay with him. Are you able to hear Mr. Whitenauer in court?
Yes, I'm able to hear him if he just stays by the microphone.
Okay. Well, he may choose to stand. I'll get him to the podium. He may choose to sit. Then he can stay there. But we'll keep him close to a microphone.
Okay, thank you.
Here at the table.
It is. Or you can be either one. I mean, she was able to hear fine from someone at the podium. Just you had sort of moved this way, and it's hard, but stay kind of tethered to the microphone. The more you sit in the middle of the table, the easier it gets. All right. So we're clear, we're dealing with 18 SC 161432, it's State versus Drain. Mr. Drain is appearing virtually from his attorney's office here in the Atlanta area. He's represented by Mr. Robinson, who is also on this call. Mr. Robinson, are you waiving Mr. Drain's right to be present here in court and accepting his virtual appearance from your office?
We are so waiving, Your Honor.
Okay. And am I correct? He's just in a different space within your office?
Correct. He's 10 feet from me in my conference room.
Okay, great. All right. So I have a notice that was filed recently by the state that seeks to get permission to admit during Mr. Drain's trial 3 other incidents that don't involve the same alleged victim in this case. 2 of them are sought to be admitted under 404B and 1 under 413. The state needs to demonstrate a proper purpose. They need to demonstrate that they could, by a preponderance, prove up each of these 3. And they need to convince me that the admission of 1 or more of these other acts would not violate 403. In other words, the probative value is not substantially outweighed by any undue or unfair prejudice to Mr. Drain. With one exception, the rape allegation, the proper purpose test doesn't apply. 413, as written and as applied by our appellate courts, doesn't impose that requirement. The state can admit other acts of that nature for any purpose, even propensity, if that's what the state wants. That's my understanding of the law that applies. At the end of Mr. Weidenauer's presentation, we can get legal on these things, but I just wanted to lay out the framework as I understand it. You guys are free to correct that if I miss something as you move forward. Mr. Weidenauer, I'm ready to hear from you, in whatever way you want to present this.
Thank you, Judge. I'd first like to call a witness who will be testifying as to transaction of aggravated assault, transaction of rape. That is Alyssa Harris. It's ALYSSA Harris, HARRIS.
Okay. Mr. Robinson, before we get Ms. Harris on the stand, I want to make sure you were aware that the state was going to call a witness, and whether or not you were aware, if you are comfortable proceeding remotely, you've got a right to be here, as does Mr. Drain. There are a bunch of reasons why it may make extra sense for you to be where you are, Mr. Drain to be where he is. But I just want to make sure we get on the record your comfort proceeding in the current format.
I am, Your Honor. Depending upon Ms. Harris' testimony, I may need to submit some documents for her to look at, and I can do so via email to Mr. Weidenauer and yourself, but I'm comfortable with the remote procedure.
Great. Then if we could get Ms. Harris to come to the witness stand, and there is conveniently a camera there, so folks will be able to see her. You need to, if you don't mind, once she's situated, adjusting the screen and you did it.
I think a copy of this and give it to him.
To the testimony, you said give to the court the truth, the whole truth, and nothing but the truth. So that's that. Please state and spell your name on the court.
Ms. Harris, you are welcome to keep your mask on if you want. You're not required to while you're testifying. It'll make it easier for the court reporter to hear you if you take your mask down. I'm not ordering you to do that, but you may see Mr. Weidenauer have his mask off when the lawyers are talking. They're free to have their masks off. And typically, the witnesses take them off as well. But it is personal preference. If you're okay with it, I ask you to do it. That way, you don't have to be right on top of the microphone as well. Okay. Thank you.
I'm sorry, ma'am. Can you repeat your name for me, please?
You don't have to be right on the microphone because that chair doesn't have wheels, so it's a little workout. You can move the chair a little bit closer. Thank you.
Ms. Harris, how are you doing today? Good. Do you know the defendant tore his drain? How do you know tore his drain? And are you able to see him on the screen here today?
Yeah.
Hold on one second. I will. All right. On the screen of Zoom, do you see, is it in front of you also?
Yes.
Okay. Do you see the person you knew and know as Torres Drake?
Yes.
Okay. I just asked if the record reflect that you identified the person entering this Zoom chat as Torres Drake. She has, and the record should reflect that. When did y'all first start dating?
Early 20 years. Okay.
Where did the two of you meet?
At 11.
What were the two of you doing?
I'm sorry, I'm not hearing her.
Pardon me?
Is her microphone on?
Yeah, it's green. It is on. Yeah, Ms. Harris, you're gonna need to get a little closer to the microphone. Yeah, but you'd be more comfortable if we just get a chair. All right, there you go. That's good. Okay. All right. So you two met at LA Fitness?
Yes.
Were you both customers there or working there? Okay. And at some point after the two of you met at LA Fitness, did y'all begin to have a dating relationship?
Yes.
And are you aware that later in 2018, Mr. Drain was arrested in relation to this case? And are you aware that subsequently he was released on bond from the Fulton County Jail? After Mr. Drain was released on bond from the Fulton County Jail, did you continue a dating relationship with Mr. Drain? And at some point after Mr. Drain was released from the Fulton County Jail on bond, did the two of you move in together? Where did the two of you move in? Okay, and
I can't hear her.
you are? Hold on one second. So we all need to, so you're gonna need to belt it out a little bit. Thank you. So if you could repeat that, do you still live at that address?
No.
Good, then repeat the address.
751 North Creek Drive, Georgia, Arkansas 24.
That was a good answer. We just want to raise our volume and speak directly into the mic. He's really loud. You don't have to be as loud as he is, but you want to try to copy Mr. Whiteman because he's like 3 feet from the microphone and boom, it's hitting. So that way it's important. Mr. Robinson can hear you, even more so Ms. Rivers, the court reporter who's making a record. Thank you. Tell me a little bit about that apartment that the two of you were staying in. 1 bedroom, 2 bedroom?
It was a 1 bedroom.
And do you recall approximately when the two of you moved into that apartment?
Around August.
And sometime after the two of you had moved into that apartment, was there an incident in which Mr. Drain brandished a firearm in your presence?
Yes.
When that happened, where were you at the time?
I was sitting on the bed.
Where was Mr. Drain?
He was sitting.
And while the two of you were in that bedroom together, what was going on before the gun was brandished?
We had been having an argument. I don't remember what it was.
And during that argument, when and how did Mr. Drain brandish the firearm?
The firearm was under the couch. He pulled it out and pressed it.
Okay. Do you recall which hand the firearm was in?
It was in his right hand.
And why and how is it that you recall him pressing it against your right temple?
Can you
Well, you
it is your recollection that it was on your right side?
Yes,
And did this firearm, was it close to you or actually touching you?
it was touching my head on the right side.
And while the gun was touching your right temple, what did Mr. Drain do?
He pressed it in my head.
And
I could not hear, she's breaking up.
Can you repeat what happened when he pressed the gun against your right temple?
He pulled the trigger of the gun.
And when he pressed the gun against your temple and pulled the trigger, what was your reaction?
I cried and asked why he did that.
And what was his response, if any?
He laughed and said that there was nothing in it anyways.
I could not hear that.
He laughed and said that there was nothing in the gun anyways.
Was there any further conversation between you and Mr. Drain after that response?
No, I just was crying with it.
And what did Mr. Drain do?
He walked out of the room.
Can you describe the firearm that Mr. Drain pointed at your temple and pulled the trigger?
It was a 9mm, top, black handle.
That's a fairly specific description of a gun. Do you have any familiarity with guns?
Yes, I do.
And was that the one and only time that you observed Mr. Drain with the gun, or had you seen him with that gun on other occasions?
I had seen him with the gun on other occasions.
And do you know if he claimed that gun as his own?
Yes.
Is it your testimony today that that was not your gun?
No, it was not my gun.
Did you know, Ms. Harris, that the gun was stored under the mattress?
Yes.
After this incident of Mr. Drain pointing the gun at you, was there another incident in which Mr. Drain committed a sexual assault against you?
Yes.
All right. And for that incident, where were you?
I was in the walk-in closet.
And are we still in the apartment that you were in of the aggravated assault?
Yes.
What were you doing in the walk-in closet?
I was.
I
And
could not hear.
I was folding clothes and cleaning up.
And was Mr. Drain present in the apartment that day?
Yes, he was.
Okay. And do you recall a period of when this incident occurred?
It was towards the end of 2019.
But after the aggravated assault?
Yes.
And before the end of the year? And while you were in the walk-in closet, did Mr. Drain come into the bedroom?
Yes, he did.
And when he had entered the bedroom, where did he go?
He walked into the walk-in closet.
And when he walked to you, how were you positioned in relation to him?
I had my back to him.
And I understand that your back was turned to him, but where do you know where he was in relation to, I guess, your back now?
He was just in front of the door frame.
Of the closet?
Yes.
And do you recall what he said to you at that time?
He asked me if I wanted to.
And what was your response to that statement?
No.
So you just spoke the words no, is that it?
Yes, I said no.
Okay. And after you communicated no to, well, first let me ask you, at that time, Did you want to have sex with Mr. Drain?
No, I didn't.
Okay. Is there a reason why you did not want to have sex with Mr. Drain?
Was really very abusive. And we had just gotten another argument about something I can't remember.
Okay. Is that your answer?
No, that's not.
Okay.
I couldn't remember because you were always arguing every day.
I couldn't hear the last part.
Every day that I lived with him, he was doing something horrible to me.
So after you said no to Mr. Drain, what did Mr. Drain then do?
He put down my pants.
How did he bend you over?
Very aggressive.
Well, so I understand your response very aggressively. Are you able to recall and tell the judge in what manner he managed to bend you over? Okay. And how? So your hands are against the wall. What position was your head and your back in relation to your legs? Okay. After he had pushed you over, what did Mr. Drain then do? Okay. And about how long did Mr. Drain rape you vaginally?
I don't know the exact time. Probably around 5 minutes.
Okay. And during that time, did you give any indication to Mr. Drain that your initial answer of no had changed?
No, I stayed quiet.
Did you stay quiet for any other reason?
I could not hear the reason for staying quiet. I'm sorry.
Best you can, speak up into the mic so that the court can hear you and also the defense counsel.
I stayed quiet because I already told him no.
And did you stay quiet for any other reason?
Because I was scared that he wasn't going to stop anything. I just wanted to be over it.
While he was raping you, were you saying anything or crying or doing anything that would indicate to Mr. Drain that still you did not want to have sex?
I wasn't reacting how I normally would if we were having sex.
You indicated that after a few minutes, he stopped raping you. When he did that, did he say or do anything?
Can you repeat the question?
Sure. You testified that at some point, after a few minutes, Mr. Drain stopped raping you. Is that correct?
Yes.
And my question is, once Mr. Drain stopped raping you, did he say or do anything?
No, he just walked out of the room.
Okay. Were you able to observe his demeanor at the time that he walked out of the room?
He just seemed angry and frustrated.
Okay. What about his demeanor made you think that he was angry and frustrated?
Because he just was, I don't know how to describe it, because it's not like he was smiling or laughing. He was just like, probably it's angry to me or looking.
And when he withdrew from you, as you just stated, and left the room, did you have any response, emotional response or verbal response?
No, I went back to cleaning up all the clothes because this isn't the first time that he's done something like abusive towards me.
Now, both of these incidents that you're testifying under oath to today occurred in the latter half of 2019. Is that right?
Yes.
Okay. And that day of the aggravated assault, or that day of the rape, did you report either of those incidents to law enforcement?
No, I didn't.
Why did you not report either incident to law enforcement that day or the day after either incident?
Because I was scared of what his reaction would be.
What? No, please allow me to, please let me, please finish your answer.
Because he had threatened me before.
Did he ever make any other threats to you about you going to the police?
Yes, he said he had connections and I don't know where I went afterwards. He was
At some point, did your relationship with Mr. Drain end?
Yes.
Do you recall when your relationship ended?
In March.
And around that time, did you receive any communication from Mr. Drain about your potential participation in this case that we're here for today?
Yes.
Okay. What did Mr. Drain communicate to you about this case and your participation in it?
He wanted me to be a character witness, as well as an alibi.
Okay. And did you agree to be an alibi witness for him?
No.
Why not?
Because that would be illegal.
Okay. Why would it be illegal in your mind to be an alibi witness for Mr. Drain?
Because I wouldn't have been able to be his alibi. I wasn't there with him at the time that he did the crime cycle.
Okay. At any time did Mr. Drain communicate to you about communicating with the victim in this instant case?
Yes, he wanted me to threaten her to not show up to the trial or be witness.
I could not hear the last portion.
He wanted me to threaten her to not show up to the trial and be a witness in it.
Did you agree to do that?
No.
Why not? At some point, did you have a conversation with Mr. Drain about possibly moving?
Yes. He.
And with that answer, yes, let me ask you, do you recall about when that conversation would have been?
It was early 2020 before his court date would have been. And he wanted to run away because he was getting scared that he wouldn't win the case.
Did you have any specifics about his desire to run away?
Yes, he wanted to go to Mexico.
Was this conversation you had, Ms. Harris, about the defendant wanting to go to Mexico, was this before or after you had ended the relationship?
It was before.
Okay, so you were still living together in the Clarkston apartment?
Yes.
When the relationship ended March 2020, did you move out or did Mr. Drain move out?
I moved out and wrote the lease.
The lease was in your name?
Yes.
So you moving out would break the lease. There would be no place then for Mr. Drain to stay. He couldn't stay in that apartment because it was your apartment.
Yes.
So let me follow up on his comment about Mexico. Did he indicate that he wanted to go to Mexico or that he wanted you to go with him to Mexico?
He wanted me to go with him to Mexico.
Did you discuss how the two of you would get to Mexico?
Yes.
What did you discuss about those plans?
He wanted to, we were just talking about how we would cross the states to get to the border. And if we did get to Mexico, it would have to stay there or move further to South America.
Was there any conversation about, by Mr. Drain, about what he would do if he were successful in his plans to flee to Mexico or South America?
Yes, he said he would probably just have to take a
cartels.
I could not hear the last portion.
Said that he would probably just have to take a work with one of the cartels.
And in response to Mr. Drain's proposal or discussion of going to Mexico or South America, what did you say, if anything? Did you have any response to his proposal or discussion of going to Mexico or South America?
I said yes at the time, but I didn't want to. I was just,
And obviously you're here today, so you did not go to Mexico. Where did you go when you broke your lease in about March of 2020?
For a few weeks, I stayed at my grandparents' house, and then I went out to California to live with my father.
Okay. And before you moved to California to live with your father, did you apply for a TPO?
Yes, I did.
And do you know whether that TPO was granted?
Yes, it was.
And after it was granted, did you receive any communication from, well, let me ask you this, was Mr. Drain the subject of that TPO?
Yes, he was.
And were you seeking that he not have any contact with you?
Yes.
And
this was, sorry to interrupt, this was after you moved out of the Clarkston apartment or before?
This was after.
Okay, but before you went to California?
Yes.
And after you applied for that TPO and it was granted, did you receive any communication from Mr. Drain?
Yes, I did.
In what form did you receive communication from Mr. Drain?
Text messages, phone calls, emails, and Cash App.
Okay. And were those communications wanted by you?
No.
So I'm sort of a tech dinosaur. I think I know what Cash App is, but how do you communicate with someone with Cash App?
He would send me $1 with a message attached to it. You can add notes on any transaction.
So a judge who doesn't know those kinds of things could say, no phone calls and no texts, and then someone creative could say, I didn't call or send a text, I actually sent her a buck. But with that buck was, I'm gonna kill you, or I miss you, come back, whatever the language of the text, the message would have been.
Yes.
I'm less of a dinosaur.
Have you been served with a subpoena to be a witness for the state in this case that we're here for today?
Yes.
And are you aware that your name is included on the state's witness list?
Yes.
And how do you feel about, now that you are a witness, how do you feel about Mr. Drain remaining on bond during the pendency of this case?
I do feel scared
Why?
because he has threatened me with murder.
Since Mr. Drain committed an aggravated assault and rape against you in late 2019, have you reported either incident to law enforcement?
I reported the sexual assault
When did you do that?
on the 19th of January.
Why did you do that?
Then just sort of two days ago?
Yes.
Okay, not 19th of January last year, but 2 days ago.
Yes.
Okay. Why did you do that?
I was. I didn't think that it would be able to happen.
Who encouraged you to get justice? Were you directed by the DA's office to contact law enforcement?
No, not at all.
Why then did you go to law enforcement?
Because the things that he did to me were really horrible, and I don't ever want them to happen to anyone.
When was the first time that you shared with someone that Mr. Drain had raped you? And why was that the first time that you had shared with someone that Mr. Drain had raped you?
I just didn't want to believe that it happened to me. My family has history of sexual abuse, and I really want to go into it as I can.
Nothing further. Thank you, Ms. Harris.
I'm just writing a couple things down. Mr. Robinson, do you have questions for Ms. Harris?
I do, Your Honor. May I proceed?
You may. I just got an email from Ms. Nelson that I think you sent to Mr. Whitenauer and Ms. Nelson with a bunch of screenshots.
Yes, Your Honor. I do not think that I will utilize them, but I wanted Mr. Whitenauer to have them and you, because at the time I wasn't sure, but I've heard the testimony, so I feel comfortable I'll proceed without them.
Okay, if you need them, let me know. I'll use share screen so that everyone, including Ms. Harris and your client, can see whatever it is we're talking about, okay?
Yes, Your Honor.
All right, so Ms. Harris, you're now going to need to answer questions from Mr. Robinson, who is Mr. Drain's attorney. Okay.
Good afternoon, Ms. Harris.
Good afternoon.
We know each other, correct?
Yes, we do.
All right. You, in fact, retained me to represent Mr. Drain, correct?
No, sir.
You did not?
No, his family did.
All right. Were you and I in communication regarding his release and his case as long as he was incarcerated?
I acted as a liaison for his family.
Okay. And you testified that your relationship with Mr. Drain began in what year and month?
It began in early 2018, either the end of January or early February.
And ended in March of 2020, correct?
Yes.
Now, you said that every day was horrible. Would you like to pull that back, or was in fact, every day of your relationship with Mr. Drain horrible?
I was getting abused by him in some way, emotionally, physically, or psychologically every single day.
And was there any physical abuse other than the incident you described with the handgun and the incident that you described of sexual assault? Was there any other physical abuse throughout the relationship?
Throughout the entire relationship, there's physical abuse.
How many times during the course of the relationship did you contact the police to report an incident of abuse?
I didn't because I was scared for my life.
So that would be 0?
Yes.
Okay. How many times did someone who overheard an argument or dispute that became loud contact the police and the police show up in response to you and Mr. Drain being in some sort of confrontation that someone overheard?
Objection calls for speculation. She can't testify, I don't think, as to who may have heard those physical arguments or heard those arguments.
Okay, I didn't hear the question asking for who made the call. What I heard was how many times did the police show up because someone, not Ms. Harris or Mr. Drain, had called the police because there was noise. Do you understand the question?
I answered the question.
You should answer it. Thank you.
The police never showed up because no one cared to call when I was screaming for help.
So 0 times?
0 times.
How many times did you tell a family member or friend of yours that you were in an abusive relationship?
I never never told anyone about the things that I went through in that relationship because it was really shameful for me.
Because what?
It was very shameful for me to
Okay.
like be in that relationship and be getting abused like that.
Okay, so I want to put aside the alleged sexual assault you described, and I want to focus on just bad arguments, bad things said to you. My boyfriend is being abusive to me. Had you ever told anyone that?
Not until after the relationship ended.
Do you have family that lived in the Atlanta area?
Yes, I had my grandparents and my sister at the time.
And you mentioned your father. Where does he live? Not specific location, but state, city.
He lives in California, but we don't have a great relationship, so I wouldn't have.
And how old is your sister?
She's 27.
And in relationship to you, how close are you in age?
We're 3 years apart.
Are you close in terms of relationship?
We are now.
Okay. During the course of your relationship with Mr. Drain, were you and your sister close? Did you communicate?
We weren't that close, and I didn't tell her about any of the abuse that was going on.
You did not.
No, I didn't. Not at the time.
Were you ever injured during the course of your relationship to the extent that you needed medical treatment?
Yes, but I didn't seek it.
What type of injury were you injured with that you did not seek medical treatment for?
My arms and legs used to be covered like black with bruises from my lips used to be busted. I used to have scratches all on the back of my neck from him strangling me. There are other things. He's kicked me. He's drowned me.
Now, you indicated that when you guys met, you were working together at LA Fitness, correct?
Yes.
How long did you work at LA Fitness? You specifically, not you and Mr. Drain.
I would say around a year, maybe less.
Up till about 2019?
Yes.
Did you work somewhere? I'm sorry?
I'm sorry, I don't remember the exact dates of when I worked there.
After LA Fitness, did you have another job?
Yes.
And where did you work?
Yard house.
I'm sorry?
Yard house.
Your Honor, at this point, I'm going to object. It's going beyond the scope of the state's direct. No questions about employment were asked on direct. It's not relevant to the aggravated assault and rape transactions listed in the motion.
Mr. Robinson, are you going to connect Ms. Harris's employment history to something, a point you want to make?
Yes.
Okay, you can keep going for a little bit.
All right, so 2019, describe your employment.
I have to go back and look at it, my resume and everything. I don't want to give it information.
Okay. Let's you recall, this is not about tripping you up. You were at LA Fitness, and then at some point you were at Yard House, which is a restaurant.
Yes.
Okay.
And then I worked at it's a salon.
Salon, like nails or hair?
Hair salon.
Good.
Did you ever have to take any time off from work as a result of having busted lips or injuries that you described that were visible?
I would actually cover up the bruises. There's only one instance where another employee saw the marks on the back of my neck from him digging his.
Where another employee saw what?
The marks on the back of my neck from him digging his nails in.
What about the busted lips?
I would cover it up.
Your busted lips?
Yes, I would use makeup to cover it up.
You indicated that you got a restraining order before going to California, correct?
Yes.
When did you go to California?
And I got to California at the end of March 2020.
In April 2020, you continued to have communication with Mr. Drain, correct?
Yes, he continued to contact me.
In fact, during April of 2020, you told him that you loved him.
Yes.
And I'm sorry?
I said I did love him still. He was my first relationship and the only person I had ever been with.
How old were you when you first met Mr. Drain and you were working at the LA Fitness?
I was 18 going on 19.
So were you in California between April 2nd and April 23rd when you were texting him that you love him?
I was in California at that time. I believe that he wanted his things that I had with me. Some other personal items that he wanted back.
Did you have a nickname for him?
Did I have a nickname for him?
Correct.
I don't believe I did.
So if you text him on April 2nd, I love you too, Chipmunk.
Your Honor, I'm going to object. If there's a text message that he wants to refer to, I'd ask that she have an opportunity to review it.
Okay, I don't think we've reached the point where he can ask the question, and you can explore what the foundation was for that, but I'm okay with it so far, overruled.
So if you text him in early April of 2020, I love you, Chipmunk, you would be referring to his nickname, Chipmunk, correct?
I don't recall.
Do you recall the date that you took out the restraining order?
I believe it was March 11th.
Now,
And this would be 2020. That's when the relationship ended. So soon after the relationship ended, you say March 11th, give or take, of 2020, you got the TPO. And so this April, maybe you're exchanging texts with him, but you're in California. That's April 2020.
Yes.
March 30th of 2020, after you've gotten the restraining order, would you have communicated to him that you wanted to keep your relationship with him going?
Before I was going to leave to California, he wanted me to go to Chicago with him. The best that I can say about that time is that I was very naive and still stuck in the mindset of having been in an abusive relationship, which I realize now. At that time, I didn't understand my thought processes, what was going on. I was recovering from shock. I almost died multiple times.
So my question to you is, would it have been, strike that. My question to you is, on March 30th of 2020, if you text him that you wanted to keep the relationship going, that may have been true, that you said that.
It was only true in the way that I didn't want to continue to get hurt by him.
All right.
I was scared that he would try to send someone to find me.
Okay.
Because as I mentioned before, he's told me multiple times that he has intentions.
Okay, so March 30th, 2020, you're not in Georgia, correct?
I would have to go back and look because I'm not sure.
All righty, and you've, March 30th, 2020, you've already involved the law authorities to protect you, correct?
Yes,
And so if you text him that at that time that you wanted to be in a relationship, the reason would be because you were afraid of him?
yes. I still am afraid of him.
I'm sorry,
I said, yes, I still am afraid of him.
but I'm asking you if at that time, March 30th of 2020, you text him that you wanted to be in a relationship with him, would that have been because you were afraid of him?
Yes, and my answer is, I still am afraid of him.
You indicated that there were monies exchanged and communications through Cash App, correct?
Yes,
How many times would you say that you sent Mr. Drain money after March 2020?
how many times did I say?
Yeah, approximately.
I'm not sure how many times. I've given him a lot of money over the time that we're together and when we were not together. I just am a good person.
I'm specifically referring to the period after March of 2020, when the relationship is ended, you, according to you, and you have moved away and filed a restraining order. Approximately how many times after March of 2020 would you say you sent him money through Cash App?
Well, it was sort of answered and Mr. Robinson's narrowing it down. You may not recall specifically, but was it 10 times? Would it have been 100 times? Or, look, I couldn't tell you, Judge, whether it's 10 or 100.
It wouldn't have been 100 times.
Okay.
I would say less than 10.
After the relationship ended, less than 10.
Yes.
Thank you.
And why were you sending him money after you had moved out of state, the relationship had ended, and there was a restraining order?
I would say that when you're being horribly abused by someone, you get used to doing things, and giving him money was something that I was used to. And yes, he did horrible things to me, but at the time I didn't want to see him go through anything bad still. So if he needed money or a ride or anything, I would still do that.
Approximately when was the last time that you sent him money?
I don't recall.
After
money in 2022, not this year, in the last 6 months.
So I stopped communicating with him last year.
Did you continue to tell Mr. Drain that you loved him up until the time that he began a new relationship? I'm sorry?
I don't recall.
Did you communicate to him that you were hurt by the fact that he started a new relationship?
I don't recall.
And it was certainly after he had started a new relationship that you made any allegation of any sort of abuse from Mr. Drain, correct?
Can you repeat the question one more time?
Well, I'll strike that. It was after he had started a relationship that you made this allegation of rape.
His relationship has nothing to do with the fact that he raped me. He raped me long before whatever relationship you're insinuating.
What was your reaction to his starting the new relationship?
I don't recall the time, but it's not really a problem for me.
That's all I have, Your Honor.
Okay, give me a sec. Ms. Harris, did you know Ms. Brown? Ms. Brown is the alleged victim in the case in front of me. And you had testified in response to one of Mr. Whitehouse's questions that Mr. Drain had asked you to threaten Ms. Brown or do something not nice to Ms. Brown. Do that. You didn't say Ms. Brown, I think, but that's who we're talking about. Did you know her?
I didn't know her personally, I just knew of her.
Through Mr. Drain?
Yes.
And you knew of her as his former girlfriend, or what was she to him as you understood it?
How he explained it to me is that she was a prostitute that he had hired on I don't know what site, but he was someone that he knew because they had had sex at some party, and then he found her on the site and invited her to my apartment.
To your apartment?
To my apartment.
Right.
While my sister and I were working.
Thank you. Mr. Whitenow, do you have any redirect?
Yes. Ms. Harris, defense counsel and Cross asked about any other abuse that you suffered at the hands of Mr. Drain. And so I want to make sure that the record is clear as to that abuse. Has Mr. Drain during your relationship ever punched your face?
Yes.
Has he ever thrown your head into a wall?
Yes.
Has he ever attempted to drown you? Has he ever strangled you to the point of passing out? Has he ever attempted to pull the steering wheel in an attempt to wreck the car while you were driving?
Yes.
Has he ever been abusive towards animals while in your presence?
Yes.
Have you ever witnessed him beat the dog? Have you
The dog, meaning your dog?
It was our shared dog. He had a cat as well.
What floor was your apartment?
Has Mr. Drain ever told you about other abuse towards animals?
Yes.
What did he describe in terms of that abuse?
Said that when he was younger, the kids up to food and
Okay. At one point, did you become pregnant during your relationship with Mr. Drain?
Yes.
And at that point, did you have a conversation with Mr. Drain about, for lack of a better word, what ground rules would need to apply about in your relationship specific to physical abuse?
Yes, I didn't want him to hit me anymore.
And did you communicate that to him?
Yes.
While you were pregnant, did he ever make any threat to you about harming you in your pregnancy?
Yes, he told me that he would poison me.
And at some point after that conversation about ground rules and what would be appropriate behavior during your pregnancy, did he violate those ground rules that you thought had been agreed upon? Y'all had this conversation about ground rules now that you were pregnant, right?
Yes.
And at, that he wouldn't hit you or hurt you anymore.
Yes.
Okay. And did that prove true after that conversation?
No.
Was there? Go ahead.
He still would continue to.
Was there an incident that occurred in a car?
Yes, he was mad because I was asleep and my phone was off. Wanted to get off work. When I picked him up, he decided that he wanted to drive. Get out of the
And for each of those times that he had used you or a dog or a cat, what was the reason that you did not tell another person or law enforcement?
I felt really trapped and really, I felt like it wouldn't help if I did. He seemed to escape his, like this case at the time. He seemed like he wasn't going to brought to justice, and I felt like I guess he was kind of.
And how do you feel now?
I still feel scared. Testifying about all this, but I want to.
Why?
Because I went through so many things that changed my entire life. And I don't want anyone else to have to.
Nothing for.
Ms. Harris, did you end the pregnancy? Did you have a kid?
I decided to stay in the motion.
How far along into that was it?
It was about 7 months.
And your understanding was that Mr. Drain was the father?
He was definitely.
Okay. I'm not crying, I just wasn't sure if that was a source of friction between the two of you as well.
He's the only person that I
Okay. So either it was Jesus number 2 or it was Mr. Drain.
Yes.
Got it. Okay. Mr. Robinson, do you have any follow-up for Ms. Harris?
Yes, I do, Your Honor. Ms. Harris, did you ever take a screenshot of any statement you made to Mr. Drain saying that, indicating that he had been abusive to you and your position on it? In other words, did you ever say anything to him about all of this abuse that you screenshotted and saved as a record for yourself?
I'm not sure. I have to go back and look.
Okay. That's all I have, Your Honor.
All right. Thank you, Mr. Robinson. Ms. Harris, I appreciate you testifying about this. But that was something that we needed to do. State prosecuting. Thank you for being here.
Thank you.
You're welcome.
You can sit down.
Dwight Howard, do you have any other witnesses you want to call?
Not with respect to aggravated assault and rape, I do have argument or presentation of a proper an argument as to the strangulation.
Okay. Why don't you, this is still your overall presentation, so share with me what you want to share on the strangulation piece, and then you can make your arguments about the different prongs, for 404B and 413.
And I'm sorry, Judge, may I just have that copy that I handed you, because I guess it's not really a copy, it's just the one I brought, but
Sure.
I can give it back to you.
Ms. Nelson got me. Oh, we actually put it on Outlook. I don't know how she got it, because it's not even a document.
Because she's not a technological dinosaur, Judge.
You must have sent it to her. So I got it. No, I know how to read the document. I can do. I know all about cash out. Whatever it is.
Yes.
Honor, probation to excuse.
Yes, I didn't. I hope you all weren't sticking around, maybe you were doing other stuff, but we are in a non-probation. Okay. Yes.
Okay. Judge, the third transaction or incident that the state wishes to have admitted in this trial would be the strangulation in the second degree that occurred on December 31, 2015. The defendant elected to proceed to a jury trial during which he testified, and the jury returned a guilty verdict on that kind of strangulation in the second. on or about June 20th, 2016. That conviction in that case stems.
I actually don't have the new one, in this area, what Ms. Nelson had.
Okay.
But that's okay, you hold on to it, I just wanted to make that clear.
Okay.
The victim in that one, Dorian, male or female?
My understanding is that that is a female, Dorian Blake. Yes.
Okay, all right, and that's something that actually went to trial?
Yes.
Okay.
And according to the GCIC, he was convicted. I've also spoken with the ABA. He tried the case and confirmed that he was convicted on that count.
That's in New York?
New York, it's in Manhattan. It's New York County, Manhattan on the east side. And we have ordered the certified county conviction.
Is that a misdemeanor or a
Felony.
felony? It's a felony, okay. Conviction. So would you at trial seek to prove it up through the conviction, or you would have, I don't remember Dorian's last name.
Dorian Blake.
You have Ms. Blake here?
Yes, it would be my intent to bring her to court with interstate compact. We have located her, but I would also be seeking to tender a certified copy of disposition.
Sure. Based on what you have learned about the New York Other Act, it would be viewed more as an act of non-sexual violence?
Yes, my understanding is that this was a domestic violence case, and there was no sexual component to the incident, to the charges, and certainly a conviction. Your Honor, the state would anticipate calling at trial the victim in that case, Dorian Blake, D-O-R-I-A-N, Blake, B-L-A-K-E, who would testify that on or about December 31st, 2015, so New Year's Eve, she was in an apartment with Torres Drain, located at 1482 York Avenue, which is in the city of Manhattan, the county of New York, in the state of New York, in apartment 4G. That he at some point became upset, having viewed some social media posts on Miss Blake's phone, and then proceeded to tie two socks together and use those around Miss Blake's neck to strangle her, and while doing so, lifting her up off the ground, and then proceeded to grab her by the neck with his hands, again lifting her off the ground. Miss Blake then losing consciousness, and officers observing on her red marks on her neck and a lump on the back of her head. Your Honor, the detail of, so I would note that this case, of course, includes one count of aggravated assault strangulation. I anticipate that the victim in this case will testify that she too was strangled on March 28, 2018 by Torres Drain. And
is that the same day as the rape, or it's a different day?
All the same day.
Okay.
He raped her, he assaulted her, he refused to let her leave, and during all of it, or at some point during it, had a firearm.
But even though it's the same day, is your understanding that Ms. Brown would say they were temporally distinct, or while I was being raped, he had his hands around my throat and he was squeezing and he was squeezing?
So I anticipate her testimony, based on my review of the police report and my interview of her, that she would testify that on March 28, 2018, that she was at that time a sex worker who had a pimp. That pimp placed a posting on Backpage, which is how the defendant Drain found her. That Drain then was texting with the pimp, and those text messages reflect that they had negotiated a price of $200. That Drain, while initially had thought about or planned to go to 4505 Best Road, which is a day's inn by the Atlanta Airport. He then inquired if perhaps Ms. Brown would come to his place, which in fact was Mr. Drain's girlfriend's place, Ms. Harris, shared by Mrs. Harris's sister, Deborah Harris, the two-bedroom apartment at 2788 Forest Ferry Road.
This is not the Clarkston apartment.
No, so this would have been 2018, and after this incident, she then did move to the apartment that is in Clarkston, which is actually in DeKalb, unincorporated DeKalb County.
So in March of 2018, Ms. Harris and Mr. Drain are dating, but they're not living together. Ms.
Correct.
Harris lives with her sister, to Forest Ferry, and Mr. Drain, according to your recitation, says that's where I want to have sex with Ms. Brown.
That's right. Okay. Because at the time, we can state will show that Ms. Harris, Ms. Alyssa Harris, was at school, and Ms. Deborah Harris was at work, and that Mr. Drain had recently quit his job at LA Fitness. That he was searching one back page, found a post that he liked, texted with who he thought was that woman, but in fact was the pimp, and that price was agreed at $200. That he then texted about her coming from the hotel to his place. He paid for an Uber, met her at the Uber when she arrived. They were briefly in the living room. That then at some point, after a few minutes, he suggests or escorts her to the bedroom. And almost immediately after entering the bedroom, he closes the door and with his right hand comes from behind her around her neck. And this is significant because it's similar to what happened in New York, lifted her up, and while lifting her up, used his other free hand to attempt to pull her pants down. She struggles and resists and tries to fight him off, but is ultimately relents when he has pushed her onto the bed and is holding her down with one hand and choking her with his right hand, I believe. At some point, is able to grab a gun and then point it at her head. At that point, she, to use a term phrase, puts her hands up and he proceeds to rape her vaginally. So the state does, and I guess I'm kind of transitioning the argument here, intend on or moves this court to admit that that December 31, 2015 strangulation of the second and the conviction for that act under 404B. As Your Honor is well aware, OCGA 24-404B states evidence of other crimes, wrongs or acts shall be admissible, not be admissible to prove the character of a person in order to show action in conformity therewith. They may, however, be admissible for other purposes, including, but not limited to, proof of motive, opportunity, intent, preparation, plan, knowledge, identity, absence, mistake, or accident. As to the strangulation case out of New York, Your Honor, I would cite to Cross v. State, cited in February of 2020. It's 354 Georgia Court of Appeals, 355. I do have a copy for Your Honor. And Mr. Robinson, if you were here, I have a copy for you too.
I'll hold it up to the camera.
Citation, Counselor.
Yep, 354 Georgia at 355 Cross v. State. Your Honor, in this case, the defendant raped the victim, and the state intended to offer two other acts under 404B. Specifically, and if you turn to page 5, 11 on the second column, it talks about how the defendant was charged in the indictment with 1 count of rape and aggravated sodomy, And the defense in this case was that the sex was consensual. I anticipate that the defense in this case will be that the sex was consensual. The defendant did provide a custodial statement after Miranda warnings were given by the detective at the time, Detective Reister, R-I-E-S-T-E-R. And during that, he acknowledged that he was with Ms. Brown on that date and portrayed that sexual interaction as consensual. So I do anticipate that that would be the defense in this case. This opinion in Cross also notes that the defendant attempted to impeach the victim by highlighting her financial interest in a civil lawsuit against her apartment complex. Now, I have no knowledge of Ms. Brown filing a lawsuit against the apartment complex there at the Forest Area. But I do, based on the cross-examination of defense counsel today, believe that the defense will attempt to attack Ms. Brown's credibility. Based on the defendant's statements during the custodial interview, that the defense will attempt to attack Ms. Brown's credibility, arguing that she was upset that his girlfriend called while Ms. Brown was there, or that she was upset that she hadn't been paid. Whatever they may do, I anticipate they're going to attack credibility. I mean, and certainly to state the obvious, they're going to attack credibility because she was, at the time, a sex worker, or as it might be referred to, prostitute. So in Cross, the state notified the defendant of its intent to introduce evidence of some other offenses to show motive, intent, and to rebut his defense consent. But at trial, they only presented two of these multiple other acts. One was a May 2008 incident in which the defendant was seen facing the window of a home with his hands in his pants. The officer testifying that it appeared that he was masturbating. And then another incident, 2015, in which a female detention officer observed the defendant masturbating in an open area of the jail. The court reviewed whether those two incidents were properly admitted at trial and found that they were. They went through the three prongs that this court's going to have to address, or will be that the evidence needs to be relevant to an issue other than bad character. The probative value of the other acts evidence cannot be outweighed substantially by some prejudice, and there must be sufficient proof to enable the jury to find that the accused committed the other acts.
So you clear that last hurdle, I believe, with the strangulation.
Yes.
Show me, so what's the proper purpose and
Balancing.
Yeah, and the balance.
Yep, I'll address those two problems, Judge. I would note that in this case, Cross, the court wrote that that when a defendant enters a plea of not guilty, it puts the prosecution to its burden of proving every element of the crime, including intent. And we would intend in having this be admitted to prove intent, plan, and to negate or rebut the defendant's argument of consent as to these sexual acts. The court noted that, in Cross, the defendant placed intent issue by pleading not guilty. Drain has done so here. His intent is clearly an issue. So we want to show that that he intended to strangle her. This is not for some rough sex act. That this was in fact a plan also because he had done this once before, only 2 years and 3 months earlier had he done this, where he lifted someone while strangling them in order to take control of them. And so that's just plan. And then of course, to rebut any claim of consent. And then I would just note in Cross that since he was attacking the credibility of the victim based on the lawsuit he had filed, or the victim had filed, and we're going to have that issue here in this case, the strangulation coming in, that other act had the tendency to bolster the credibility of the victim by demonstrating that her circumstances were not unique. And that's what we would intend to do here. As for prejudice, the court at Cross did consider Rule 403 and the balancing test, noting, as this court is aware, that it is an extraordinary remedy which should be used sparingly since it permits the trial to exclude concededly probative evidence. So it should be struck in favor of admissibility. So the court needs to weigh the prosecutorial need, the overall similarity between the extrinsic act and the charged offense, and the temporal remoteness. Just as in Cross, the need was great. The need is great here. We have a he said, she said. The only witness to this aggravated assault strangulation will be Jasmine Brown. True, there is Officer Cunningham who responds on scene and does observe red markings around her neck. And then there's also photos from the hospital at Grady that appear to show what have now started to turn into bruising on her neck. But as for the incident itself, Ms. Brown will be the only witness to the aggravated assault strangulation. So there is a great need for the prosecution to have this admitted. A similarity, I mean, I don't know how much closer it could be. You have defendant choking and lifting one victim in New York. You have him here in Georgia choking first with his forearm and then, well, just with his forearm and lifting. There's very clear similarity between those two things. And I was thinking about this. You know, there are a lot of different ways to choke someone. You can use your hands, use socks, apparently. You can stomp on their throat. You can tie something around their throat. But for Mr. Drain, it appears that he likes to combine choking and lifting to incapacitate that person, whether it be Ms. Blake or Ms. Brown. And then temporal remoteness. You know, in Cross, one incident, the instant case was 2009. The other acts were 2008 and 2015. Here, we're talking about December 31st, 2015 to March 28th, 2018. We're talking 2 years and 3 months. So pretty close in time, and courts have found that even a time span of 12 years is not too remote. And then lastly, talk about, you know, whether this is going to be too prejudicial. And the court noted that, you know, that the other acts that were admitted were not so heinous of a nature that it would inflame the passions of the jury such that they could not consider the elements of each crime's charged in the indictment. And, you know, I think here we're dealing with an aggravated assault strangulation. We're asking the court to admit another strangulation. We're not trying to get in child molestation, murder, what have you. So again, I think it's similar to Cross's ruling that we're not talking about something that's going to inflame the passions of the jury. And so we do think that it would be appropriately admitted under 404B under the first and second prongs of that analysis.
Okay. What about the two situations involving Ms. Harris?
Yes.
Why don't you do the 404B one, which would be the strangulation?
Yes.
And then you can handle the sexual assault last, because I think it's slightly simpler analysis for it.
I agree. For the aggravated assault with the deadly weapon against Ms. Harris, my analysis is fairly similar to the one that I offer for the strangulation up in New York. Again, for this case, there is another count of aggravated assault with a deadly weapon, that being the defendant pointing at Ms. Brown right before he rapes her. And so again, here we are, and he said, she said situation. And so there is a great need for the prosecution to show to the jury that the defendant did in fact have that intent to possess and use that firearm in assaulting Ms. Brown, and to negate or rebut any argument that this was a consensual act, that this gun somehow was part of some rough sex role play act. So there is a need for the prosecution to admit that evidence to show that he did have an intent to possess the gun. And then similarity, well, I'll say that Ms. Brown reported to law enforcement and then to me while I interviewed her, that the gun that Mr. Drain used against her was a black and silver Glock. She was not able to state, caliber, but we have Ms. Brown with a black and silver Glock, a handgun, and over here, Ms. Harris, a black and silver 9mm Glock, a handgun. And so I think here, the language in Cross, where they cited another case, Blevins v. State, that other act, the aggravated assault with a deadly weapon, had the tendency to bolster the credibility of the victim by demonstrating that, again, her circumstances were not unique. And then talking about temporal remoteness, we're talking about March 28, 2018 to late 2019. So we're talking about a year and a half, even less than the time period between this incident and the strangulation. So I don't think there's an issue there on temporal remoteness.
And Ms. Brown get specific about whether the gun was pressed up against the temple or just waved at her or brandished?
Yes, Judge, she did. If you give me a moment to go back to my notes with her. Where is she? Sorry, I've expanded also a couple of different. I just have one moment. Your Honor, so when I interviewed Ms. Brown, she indicated that just before the gun was brandished, the defendant had turned the victim over, was choking her, that she could not breathe. That the defendant said, "You're going to listen." She was coughing, and he grabbed the gun, it was in his right hand, and then he placed it to her temple, saying, "You're making this hard for yourself." Again, placing the gun directly at the victim's head, a lot of similarity there. It's, again, just like you can choke someone in a lot of different ways, you can point a gun in a lot of different ways. You can, point it out from a distance, say, "Get undressed and come over here and do this." In this case, Mr. Drain points it right to the temple. So I think it's the state's argument that that this aggravated assault is relevant to an issue other than that character, that being his intent to rebut or negate a defense argument of consent. And then the probative value is not outweighed substantially by unfair prejudice. This case in chief involves a firearm, and the 404B transaction is a firearm. Again, we're not talking about child molestation and some other more heinous crime. For all those reasons, I'd ask that the strangulation and aggravated assault be admitted on 404B. And then lastly, I'll try to briefly address the rape of Ms. Harris by Mr. Drain. Controlling law, that is OCGA 24-4-413, an A, which reads in a criminal proceeding in which the accused is accused of an offense of sexual assault, evidence of the accused commission of another offense of sexual assault shall be admissible and may be considered court-bearing on any matter to which it is relevant. So we have testimony today of Ms. Harris that in sometime late 2019, Mr. Drain raped her after she clearly told him no. This court will have to make a determination of credibility now that you've had an opportunity to see her on the stand under oath and ask questions of her yourself. And she, to me, has always presented as credible when she first told me about it in late December, and in the subsequent conversations I've had with her. We would be seeking to admit it for the purposes of intent, propensity, and again, to negate or rebut any argument of consent. We would ask that that also be admitted, but under 413.
Okay. Mr. Robinson, your argument as to why any of these three should not be admitted under 404B or 413.
Well, Your Honor, as it relates to the aggravated assault, the strangulation in New York from 2015 that is sought to be admitted under intent, according to the court in Cross, and I understand this to be the law, the issue of intent is the issue of the defendant's similar state of mind. There's nothing similar in terms of the intent from the strangulation case and the intent in the case at Chief. The state of mind is completely different. The only similarity that the state brings before the court is that there's a lifting motion accompanied by a choking motion. I don't think that in any way goes to the intent or state of mind that is for the jury to determine in this case. So therefore, I think that particular prong of the 404 determination has not been met. If this case of the strangulation is admitted on top of the allegations from Ms. Harris, I would submit that that would cause the strangulation case to have much greater prejudice than probative value, because what it does, if combined with the Harris matter, it morphs the nature of the circumstances into a domestic violence abuser case. My understanding from the strangulation case, there was a relationship between the parties and jealousy on the part of Mr. Drain, which precipitated this incident. So I would submit, as it relates to New York, one, the intent prong is not satisfied. Secondly, the 403 probative prejudicial impact would weigh against admission, particularly if it's combined with the Harris matter, because it changes the entire nature of the case. It certainly does from our perspective of trying to defend Mr. Drain. As it relates to Ms. Harris, that's a bit more complicated. And I do not believe that the rape allegation that's now, I guess, ripened into at least a presentation of the case to the DeKalb authorities. I don't believe that there's anything in the two matters, the case in chief and the rape allegation of Harris, that indicates any similarity of intent or motive or procedure or how he goes about things. So I would submit that as it relates to the rape, that prong is not satisfied. As it relates to the placing of the gun, there is similarity. And I cannot dispute that. But again, it's a non-sexual situation. It's an allegation of a non-sexual assault. And therein lies the differentiation that I would submit to the court causes the prejudicial impact to substantially outweigh the probative value of the placing of the gun evidence. So therefore, we'd ask the court to exclude both the Harris allegations as well as the strangulation in New York.
I followed all of that, except I want to circle back to the sexual assault 413. You're saying it's different intent. I didn't follow you on that for two reasons. One, what was different about the intent? And then two, I don't know that that's necessarily a requirement. The state has provided some purposes for which it might seek to admit the sexual assault against Ms. Harris. It really doesn't need to, because the statute says it is admissible for any purpose. And so my understanding of the analysis I'm supposed to apply to a 413, which would be the sexual assault on Ms. Harris, is can the state prove it? And then rule 403. But I don't want to miss something. So if you would walk me through that argument one more time as to why you think the sexual assault on Ms. Harris ought not to come in, because you were talking about it's a different type of intent, and I'm
Yeah, I got you, Your Honor. Yeah, as I said, that is a little bit more complicated in as much as the state has had the court has had an opportunity to assess Ms. Harris. And when you look at 413, it's kind of there. But the thing that isn't there, Your Honor, is while they're both sexual offenses, you've morphed this into, not you being the court, but the matter has been morphed into this 2-year situation of horrible abuse, if that's where the state is going with it, versus the limited act. And that 2-year history of horrific abuse, I think, creates the circumstances under which it becomes extremely more prejudicial, substantially more prejudicial than probative, even considering the threshold of the 413 that 413 that is in all likelihood met in this case.
All right, I think I got that. Let me play it back as I understood it. As a standalone incident, if all Ms. Harris experienced for her testimony at the hands of Mr. Drain was the sexual assault, when I say all, I don't mean to minimize it, but if that was the sum total of it, then you're saying, Mr. Robinson, that's a tough one to defend against. It might well come in. But the way we heard about it today, it was part of, as you pursued in your cross-examination, every day something horrible happened. And it begins to be painting the portrait of Mr. Drain as a serial abuser. She may well be, don't know, that's not what I'm here to decide. But your concern is for the state to try to enforce the credibility of Ms. Harris, and well, wait, how could there be this event and you don't tell anyone about it? They would want to paint a more complete picture of Ms. Harris's perspective of the nature of her relationship with Mr. Drain, which then gets us sharing with the jury all these other things which aren't 413.
That's correct, Your Honor.
Okay, that's helpful. Thank you. Mr. Whitehour, you can respond as the movement, the person providing notice. You can respond to any of those if you want. I'd ask you just to focus on that last one that Mr. Robinson and I went back and forth on, now that I better understand it. I understand both of you on the strangulation, aggravated assault, and the aggravated assault gun to temple. But what about that concern of Mr. Robinson's, that really for you to put the sexual assault allegation from Ms. Harris in perspective, jury's going to be hearing about all these other things, whether it's tearing the jaws of kittens apart or this or that, and that's 404B. And I don't think that, I'm not aware of a principle of law that says, because you can get this 413 in order to make it more persuasive, you can for free get all this 404B.
Yes, Judge. And so, I have only noticed those three specific instances: strangulation, aggravated assault, and level rape. And it's not my intent to go into all of the other abuse that Ms. Harris did suffer at the hands of Mr. Drain.
Unless the door is open.
Unless the door is open,
Okay.
and as it was today.
Okay. And I appreciate both sides, and you weren't objecting because you were both exploring things, and Mr. Robinson might ask very different questions of Ms. Drain in front of the jury. But that's going to help me now, as long as you are not expecting, Mr. Whitehour, that if I were to conclude that under 413, the sexual assault against Ms. Harris comes in, that was carte blanche for you and Ms. Harris to share with the jury all these other things, because it's not what it would be. It might end up going that way depending on how cross-examination went. It certainly creates a complicated landscape for Mr. Robinson, but he's navigating things like that. Okay. All right, that was helpful. Did you have anything else you wanted to add? You answered my one question, but anything else in response to what Mr. Robinson had said?
Yeah, I think all of these are appropriately admitted under 404B.
Okay. All right. Mr. Whitenauer, are you still on track to be, I know you have a family situation that may put the kibosh on you being involved, but is the state still on track being ready to proceed with this the week of February 2, if we are doing jury trials then?
Judge, I mean, if Your Honor calls the case, I don't know that the state has much of an option to find a way to be ready. I'm preparing it so that another prosecutor could try the case if that is what we're to happen.
Okay. Mr. Robinson, do you remain in a position to go forward with trial if we reach this case the week of February 2?
That would depend upon the court's ruling. I think that as it relates to Ms. Harris, I would need to get not only the transcript from her testimony today, but probably need a few more weeks to nail down my cross-examination and impeachment of her. So that's where we would be.
Okay. Got it. And your client is in town now. How long is he able to stay in town?
He is at the court's pleasure.
Okay.
He is working. I believe he took off the time to work, so he's balancing that, but he understands his obligation to the court.
Got it. Mr. Whitenauer, anything more you want to say on the question of bond?
Yes, Judge, thank you. I would renew the state's motion to revoke bond now that Your Honor's had an opportunity to hear from Ms. Harris, specifically her testimony about how while that after the March 28, 2018 incident, she was contacted by Mr. Drain with direction or request to contact the other victim, Ms. Brown, and to threaten her regarding attendance at trial, and separate communication asking that she serve as an alibi witness, which of course she couldn't because she wasn't there that day at the apartment. Their conversation about going to Mexico and discussions of how to get to the border, what to do when there, and noting that was coming up that she recalls that was coming up on a court or a trial day, as we are now. Your Honor, and then separately, Your Honor, having heard from Ms. Harris that after he is released on bond, he is in possession of a firearm, and it isn't just in possession of a firearm, but points it at her and pulls the trigger, laughing about it, and then on a separate occasion rapes Ms. Harris. So if believed, having committed 2 felonies while out on bond, well, at least 2 felonies while out on bond. So that testimony in combination with her testimony of direction or request from the defendant, make me concerned about the defendant's risk of flight, the defendant's risk of intimidating witnesses in the case of Ms. Harris and Ms. Brown, and certainly committing further felonies while this case is pending. And I understand that there may be only a few weeks before this case is heard at trial, but a lot can happen in a few weeks. And given the information this court has been provided now, I think it would be reasonable to revoke this defendant's bond because he does not meet all 4 factors laid out.
Mr. Robinson?
Your Honor, Mr. Drain came to court several times, I believe, after his release on bond. He appeared before Your Honor on a trial calendar or a calendar call some time ago. He's appeared before Your Honor on several times. He makes it a point to make sure he's where he needs to be and to honor his commitment to the court and honor his bond obligations. He's done nothing else. And this theory about fleeing to Mexico, it is what it is, but he has not in any way indicated that he's going to do anything other than be where he needs to be and be prepared. He's supplied me with screenshots to attempt to impeach Ms. Harris. We're going to do what we need to do as it relates to Ms. Harris. We submit that we believe, not submit, but we believe that she's not telling the truth as it relates to these things and wants to see him in custody because she's spiteful. But I would think that the greatest testimony as to Mr. Drain's risk of flight is his own actions. And he's demonstrated nothing but appropriate actions up until this point, Your Honor, before the court.
All right. Thank you for sharing that. I'm just looking at the calendar here. I need to get an order in on the 404B and 413. That will be early next week that I do that. Mr. Robinson, you're saying based on that order, on how it breaks, you might be asking for a continuance from February 2 so that you and your client can be more adequately prepared to counter the 413, 404B, if I rule in favor of admission. If it is being excluded, then you're more apt to be ready to go to pick a jury on February 2.
That's correct, Your Honor.
Okay. All right. And Mr. Whitenauer, your plan, should your final child arrive, is that you're taking a few weeks up front and then you're back and then you're taking a lot of time. Am I remembering correctly that it's a quick break up front to be where you ought to be? Then you come back, your wife will do the heavy lifting, and then it'll be your turn.
Correct.
Okay. And how much time are you taking off when that time starts?
The long haul would be.
The short haul.
The short haul, I anticipate, if it's a normal delivery, 2 weeks.
Okay. And the expected due date is?
February 10th.
Give or take. Got it. Okay. I have the information I need. I'm going to take both questions under advisement, the other acts, evidence, and what to do with bond. But because I'm not ruling on either, Mr. Drain remains on bond at this point, subject to all those conditions. It may be that I want to get folks together one more time in advance of the trial date to clear a few things up. And if I do, I want Mr. Drain to come to court, not just be in Mr. Robinson's office, but to come like you did last time, Mr. Drain, to courtroom 8D. And I know that's an inconvenience because you're not coming from Conyers or Smyrna, but from another state. But it's an obligation you have, and to Mr. Robinson's point, it reinforces his argument that you are not a flight risk, which is the premier factor I'm supposed to weigh. It's not the only factor, and others can outweigh that, but it certainly inures to your benefit that you keep showing up for all this.
Yes, Your Honor, I'll be here.
Okay. Mr. Whitenauer, anything else? Mr. Robinson?
No, Your Honor.
Okay. Thank you, everyone.
All right.
Thanks, Ms. Rivers.